ಟೋಟಲ್ 13 ಲೈಟ್ ಚಾರ್ಟ್ ಆಫ್ ಮಾಡಿ ಸರ್. ಮತ್ತೆ 12 ಎನೇಬಲ್ ಮಾಡಿಲ್ಲ, ಆಪ್ಷನ್ ತೋರಿಸ್ತಾ ಇಲ್ಲ. ಮೋರ್ ಆಪ್ಷನ್ ಲೈವ್ ಸ್ಟ್ರೀಮ್ ಇಲ್ಲ, ಲೈವ್ ಸ್ಟ್ರೀಮ್ಗೆ ಮೋರ್ ಆಪ್ಷನ್ ತೋರಿಸ್ತಾ ಇಲ್ಲ. ಟೋಟಲ್ 12. ಒಂದು ನಿಮಿಷ ಸರ್ ಹೇಳ್ತೀನಿ. ಸರ್ 7254. ಹಾ ಸರ್.
What a fresh matter could be. Please give fresh matter. Huh? Huh? ಈಗ ಸದ್ಯಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಬಿ ಗ್ರೂಪ್ ಈಗ ಸದ್ಯಕ್ಕೆ ಆಗೋದಿಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ UTCL ರಿಲೀಸ್ ಮಾಡ್ತೀನಿ ಕೊಡಿ ಆಯ್ತು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನೋಡೋಣ ಕೊಡಿ ಆಗತ್ತಿಲ್ಲ ನೋ ಸರ್ ಕೊಡಿ ನಾಳೆ ಬರುತ್ತೆ ಕೊಡಿ ಏನು ಆಗೋದಿಲ್ಲ we can still tell them not to proceed with the confirmation of it. ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಾ ಹಿಂದೆ ಲಿಸ್ಟ್ ಆಗಿತ್ತಾ ಮತ್ತೆ ಯಾರು how are you saying date is given ನೀವು ನಿಮ್ಮ ಮೆಮೋಲ್ ಹಾಕ್ತೀರಾ that doesn't mean it's a date given matter ಕೊಡಿ give it please give it sir madam if it is a fresh matter you please give it otherwise you please don't give it now I will see from next week not now yes I am saying if it is not a fresh matter we will see next week don't move it now yes kodi please give B group your subject move mabdi we will see next week yes that's all right I am not going to allow any old matters now I'll see next week please wait for next week yes
I appear for the petitioners matters
ನೋಡ್ರಿ ಅದು ಯಾವ್ದು 230 ಕರೀರಿ ಅದು tomorrow yes no sir no final matters now please wait next week I'll see yes
Lord, I appear for the petitioners matters. Lord, this is a case where appointments on compassionate grounds. Petitioner's father was working as a C group and posts are there, my lord. He has been given a D group, but page 21 endorsement was issued by the administrative officer.
Who appears for agricultural university?
Srinivas is there, my lord. I will serve a notice on.
How Srinivas, sir?
M. Srinivas.
Huh?
M. Srinivas.
Learned Council Shri M. Srinivas is directed to take notice for all the respondents. Learned Council for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the Learned Council for the respondent.
Obliged.
My lordship, I am appearing for respondent number 1 and 2.
Huh? Huh? Ah. Hmm. $200% ex gratia. ಅದೇ ಈ ತರ ಅನ್ರೀಸನಬಲ್ ಡಿಮಾಂಡ್ಸ್ ಮಾಡಿದ್ರೆ ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ? 200% ಎಕ್ಸ್ ಗ್ರಾಷಿಯಾ ಕೊಡಿ ಅಂತಂದ್ರೆ who appeared for this HMT? ಮುರಳೀಧರ್.
I am for the
Muralidhar.
number 1 and 2, my lord.
ಇದಾರಲ್ಲ.
I am for 1 and 2, my lordship. Respondent number.
Learned Central Government Council. Sri Nagendra A has entered appearance. You have been directed to take notice, is it? Has entered appearance for response number 1 and 2. Learned Counsel Sri H.M. Muralidhara is directed to take notice for response number 3 and 4. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent. Yes. For regularization. Page number? It's pending. Who appeared for the respondent there? Sriranga. Now is the senior counsel. ಯಾರೋ ಹೇಳಿದ್ವಲ್ಲ KPTC ಎಲ್ಲ ಯಾವ್ದಿದು? Descom. ಯಾರಿಗೆ? Descom. ಮೂರ್ಕು ಬೇರೆ ಬೇರೆ ಇದ್ದಾರೆ. ಯಾರು? Discom. KPTCL. Discom ಮಾತ್ರ ತೋರಿಸಿದಾರಪ್ಪ. Discom ಎಲ್ಲ ತೋರಿಸಿಲ್ಲ. Anyway, I will direct notice. You consult them. If they take the notice, then let them come and say we'll also take notice for them. Learned AGA takes notice for respondent number 1. Learned Counsel Sri A. Chandrachuda is directed to take notice for response number 2 and 3. Issue notice to response number 3 and 4. Learned Counsel for the petitioner is directed to serve copies of the petition along with annexures on the Learned AGA and Learned Counsel Sri A. Chandrachuda. 2 sets of copies to Learned Counsel Sri A. Chandrachuda. Yes. Number 4. Also, huh? Huh? No, your mother is already working. What is the concept of compassionate appointment? Who has deserted you? Your mother has deserted you. ಅದೇನ್ರಿ ಡೆಸರ್ಟೆಡ್ ಯು ಅಂದ್ರೆ ಏನ್ರಿ ಅರ್ಥ? ಎಲ್ಲಿದ್ದಾರೆ? Learned Counsel Sri B.L. Sanjeev is directed to take notice for the respondent. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on the Learned Counsel for respondent.
My lord, I appear for the petitioner in this matter, my lord. I have challenged the suspension order passed by, my lord, the Director of Municipal Administration. The petitioner is, my lord, working as a FDA in Hassan municipality. My lord, as per order at Annexure A, page 19, he has been kept under suspension. My lord, it is done on the complaint filed by the president of the municipality. Lord, the allegation is that, my lord, in a phone conversation with another employee, I have made certain allegations against the president. That is the allegation. He provides a CD, my lord, to the along with the complaint. My lord, I have denied that CD is with my. It contains my voice. My lord, your lordship may kindly see Annexure E, page 26, which is the complaint by the municipality. Along with this complaint, he provides a CD. Not Annexure F is the show cause notice issued to me. ಅದರಲ್ಲಿ 2ನೇ ಪಾರದಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಸದರಿ ಧ್ವನಿ ಮುದ್ರಿತ ಸಿಡಿಯನ್ನು ಆಲಿಸಲಾಗಿತ್ತು. ಅದರಲ್ಲಿ ನೀವಿಬ್ಬರು ಪಾನಮತ್ತರಾಗಿ ಪರಸ್ಪರ ನಡೆಸುವ ಸಂಭಾಷಣೆಯಲ್ಲಿ ಬರೀ ಅವಾಚ್ಯ ಶಬ್ದಗಳೇ ತುಂಬಿದ್ದು. ಅದರಲ್ಲಿ ಅಧ್ಯಕ್ಷರನ್ನು ನಿಂದಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. As this allegation, then I have denied, my lord, it is the CD is, my lord, concocted and it is
that has to be sent to FSL report. Report has to be obtained.
Please, my lord.
ಮತ್ತೆ?
My lord, it's the CD is itself is provided by that complainant, and not, my lord, it is not allegation is not that, my lord, in a public place I have scolded him, not like that. It's only on a phone conversation between 2 persons, my lord. How they have obtained the CD, my lord, etc., is not forthcoming.
All those things will come out only after an inquiry is held, sir.
My lord, prima facie, my lord, while forming an opinion, prima facie opinion has to be formed, and it is only done on a recommendation of the, my lord, the deputy commissioner.
Learned AGA takes notice for response number 1 and 2. Issue notice to respond number 3. Learned Counsel for the petitioner is directed to serve a copy of the petition along with annexures on the Learned AGA.
My lord, respondent number 3, my lord, A. Ravishankar, Learned Counsel A. Ravishankar appears, my lord, Hassan municipality. Permitted to.
Learned Counsel Sri A. Ravishankar.
Please, my lord, please.
Who normally appears for the 3rd respondent, CMC.
Please.
He is directed to take notice for the 3rd respondent. Copy it to Learned AGA and 2 sets of copies to Learned Counsel for respondent number 3.
My lord, interim order, my lord.
No.
Kindly, my lord.
No, sir. Huh? What happened? You had earlier come before this court. What happened? the petitioner has now preferred discipline on the score that the respondent bank has not paid consequential benefits that would flow from the orders extracted herein. Consequential benefits, according to the petitioner, would mean service benefits. But the petitioner has sought for quashing of an affidavit that was filed in a contempt petition, which cannot be entertained before this court. Challenge the action of the respondent bank in not paying consequential benefits. Annexure?
The joint compromise memo shall form part of the records order.
Record a joint compromise memo. It is agreed that the bank shall pay 25% per centum of back wages to the petitioner from so and so instead of 50%. As that, the petitioner has agreed to accept the same. Further agreed that such amount will be paid within 8 weeks from today. The compromise arrived. So there is already a compromise. Then you should have filed an application before the division bench. If there is compromise entered into between the parties in the presence of the court, and if that compromise is not acted upon, you could have filed an application before the division bench. Annexure? Why did you file the writ petition? How can you challenge a compromise petition? Correct, sir. When you admit that you entered into a compromise between in the presence of the court, how can you now go back upon that one? I'm not now going. Now I proceed the respondent to compliant andre alli application hakbekagittu. Why did you file a fresh writ petition? Where was the need to file a fresh writ petition? If you are insisting on execution of that compromise entered to be before the court, for non-compliance, you should have filed an application there. Therefore, petitioner is reserved liberty to challenge the action of the respondent bank in not paying contribution, which was part of the joint memo in a manner known to law. Andre yen artha? You thought you are allowed to file one more petition. ಸರಿಯಾಗಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ ನೀವು. ಯು ಡೋಂಟ್ ವಾಂಟ್ ಟು ಟೇಕ್ ದಿ ಅಸಿಸ್ಟೆನ್ಸ್ ಆಫ್ ಅಡ್ವೊಕೇಟ್ಸ್. ನಮ್ಗೆಲ್ಲ ಗೊತ್ತು ಅನ್ನೋ ರೀತಿಲಿ ನೀವೇ ಬರ್ತೀರಾ ಮುಂದೆ ಕೋರ್ಟ್ ಮುಂದೆ. ಇದೇ ಆಗೋದು. You wrongly read the orders passed by this court in a manner known to law ಅಂದ್ರೆ ಅರ್ಥ ಏನು? ಇನ್ನೊಂದು ರಿಪಿಟೇಷನ್ ಫೈಲ್ ಮಾಡಿ ಅಂತನಾ? You are seeking implementation of the compromise petition entered into between the two parties before the court. If there is non-compliance, you could have filed an application before the division bench. ಏನ್ ಮಾಡ್ತೀರಾ? Who appeared for the bank? GKV Murthy. ಯಾರೋ ಅಶೋಕ್ ಜಿವಿ ಅಂತ ಅಪಿಯರ್ ಆಗಿದ್ರು. ಅವ್ರೇನು ಸೀನಿಯರ್ ಕೌನ್ಸಿಲರ್? ಅದಕ್ಕೆ ಅಶೋಕ್ ಜೀವಿ. Learned Counsel Shri Ashok GV is directed to take notice for the respondent. The petitioner, party in person, is directed to serve 2 sets of copies of the writ petition along with annexures on learned counsel for the respondent. ಯಾವಾಗ ಎಂಟ್ರೆಸ್ಟ್ಮೆಂಟ್ ಆಗಿರೋದು? 2017. Learned AGA takes notice for respondent number 1. ಬೇರೆ ಯಾರಿದಾರಮ್ಮ BBMP ಗೆ?
BBMP TM Venkatreddy Milad. TM Venkatreddy.
Learned Counsel Shri TM Venkatreddy, who is present through video conference, submits that he would take notice for respondent number 2 BBMP. Learned Counsel Shri ಯಾರು ಎಂತ ಅರ್ಬಟ್ಟಿ Venkatesh Arbatti is directed to take notice for respondent number 3 and 4. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent.
Very well.
2017, sir. No, let us see. Let them come. List this matter. List this matter on 10th of March.
And for the petitioner, my lord. Madam, for the petitioner, my lord.
ಯಾವುದು ಇದು? ಸೀರಿಯಲ್ ನಂಬರ್ 10.
9, my lord.
9. 9. Yes.
My lord, petitioner is working as assistant executive engineer in the Karnataka Rural Infrastructure Development Corporation, my lord. My lord, a complaint was lodged alleging that he has amassed wealth disproportionate to his known source of income. My lord, after investigation, my lord, Lokayukta police submitted a report stating that there is no basis in the complaint and the income and assets, my lord, there is variation to minus, it is in the negative. My lord, at that stage, instead of closing the complaint, my lord, Lokayukta sought clarification from the corporation whether he had taken prior permission of the department while acquiring the immovable properties, my lord, from in 1996 and onwards. But the department stated that he has not obtained prior permission. Based on that, my lord, an entrustment was made under Rule 14E of CCA rules, my lord, by the first respondent government, my lord. But that was challenged by me along with the report on the allegation on the ground that, my lord, that the entrustment is bad in law and, my lord, that the very initiation of inquiry is hit by section 8(1)(b) of the Lokayukta Act. Lord, in the meantime, Lord, the division bench having held that a person, a public servant, Lord, government has no authority to initiate inquiry or entrust the inquiry. Lord, on that ground, Lord, the writ petition came to be disposed of by an order dated 19th August 2021, Lord, page 46, Lord. Lord, your lordship may kindly see page 51, my lord. Para 5, my lord. Para 5. In the circumstances, the first respondent state shall transmit the report received under section 12(3) of the Karnataka Lokayukta Act to the managing director, second respondent forthwith. On receipt of the aforesaid report, the managing director of the second respondent disciplinary authority is at liberty to appoint the inquiry officer for conducting the inquiry against the petitioner herein in accordance with the law and having regard to the insertion of Rule 96A of the C&R rules of the fourth respondent. All contentions raised by both the sides on merit of the allegations against the petitioner herein are kept open to be raised at appropriate time before appropriate authorities. Now, my lord, based on this, my lord, annexure G came to be passed, my lord, page 53. My lord, here, my lord, your lordship may kindly see page 54 for a moment, my lord. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ಮೇಲ್ಕಂಡ ತೀರ್ಪಿನಲ್ಲಿ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಸಂಸ್ಥೆಯು ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಾವಳಿಯ 96ರ ನಿಯಮ 96A ರಂತೆ ಕ್ರಮ ವಹಿಸಬಹುದಾಗಿದೆ ಎಂದು ತಿಳಿಸಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ಕೆಳಕಂಡ ಆದೇಶ. Lord, 12.3 report, based on the 12.3 report, my lord, they have entrusted the inquiry under section 12.4 of the Lokayukta Act, my lord. My lord, the very entrustment is bad in law because, my lord, section 12.3 specifically says, my lord, that the disciplinary competent authority shall examine the report. Now, my lord, I am coming to the legal issue, my lord. The only allegation is that he had not taken prior permission from the authorities, my lord, under section rule 23 of the conduct rules 1966, my lord. My lord, you may kindly see section 8(1)B of the Lokayukta Act for a moment, my lord. Matters not subject to investigation, except as hereinafter provided, the Lokayukta or Upalokayukta shall not conduct any investigation under this act in case of complaint involving a grievance in respect of any action, if such action relates to any matter specified in Schedule 2, second schedule. Last, may kindly see second schedule for a moment, my lord.
That is investigating into the matter.
No, the investigation, my lord, the very initial investigation, my lord, was with regard to the disproportionate to non-social. Then they sought clarification. At that stage, my lord, the clarification that was given is that he has not obtained prior permission.
Yes.
Now, my lord, on the basis of that, they have initiated the inquiry.
Correct.
That inquiry, my lord, itself is hit by section 8(1)B for the reason.
No, sir. The entrustment is different. You are talking of section A, which is pertaining to investigation.
Yes, my lord. After investigation only the report has been submitted, my lord.
Sir, it is not because of that. It is now directly done by the managing director.
Yes,
after the matter was remanded back by the division bench.
Yes,
the
competent
authority has looked into the matter and now entrusted it.
Yes,
so section 8 will not come to play.
Well, when the entrustment is being made, my lord, section 12.4 is the one which come into force, my lord. Your lordship may kindly see section 12.4, my lord. The competent authority shall examine the report forwarded to it under subsection 3 and within 3 months of the date of receipt of the report, intimate or cause to be intimated to the Lokayukta or the Upalokayukta action taken or proposed to be taken on the basis of the report. That means, my lord, it shall examine the report. My lord, it has to first come to conclusion whether there is a case for entrustment of inquiry under Rule 14 or not. Now, your last may kindly see the improved order that is passed, my lord. Page 55.
Rule 14.
My lord, that is now inserted under 96A, my lord. That is the corporation has inserted 96A, my lord. Now, your lordship may kindly see page 54, my lord.
96A
in the Karnataka Rural Infrastructure Development Corporation regulations, my lord. Under that, my lord, they have inserted to my lord, proceed with the entrustment of inquiry to Lokayukta, my lord, which was not available at earlier, my lord. Now, your lordship may kindly come to
let us see. Let them come.
My only humble submission is this, my lord. The entrustment itself is bad in law, my lord.
You are admitting that you have not taken permission. What else is there, sir?
No, my lord, I am not. No. My
Mother?
lord, there is no provision for permission itself.
After verification,
No,
the
my lord.
department is saying you have not taken any permission.
No, my lord, your lordship may kindly come to page 12, my lord, of the petition.
Page?
Page 12, my lord.
Ah.
My lord, without prejudice, para 15, my lord.
Ah.
Without prejudice to the above contention, the petitioner further submits that Rule 23 of KCS conduct rules reads as under. No government servant shall, except with the previous knowledge of the prescribed authority, acquire or dispose of any immovable property by lease, mortgage, purchase, sale, gift, or otherwise, either in his own name or in the name of any member of his family.
Yes.
My lord, it is not prior permission, my lord, with the previous knowledge. Now, my lord, your lordship may kindly come to the document which I have produced, my lord. I had informed the higher officer, my lord, page 22. My lord, in the middle, my lord, ನಾನು ನಿಗಮದಲ್ಲಿ ಸೇವೆಯನ್ನು ಸಲ್ಲಿಸುತ್ತಿದ್ದು.
What is this? Annexure B.
Yes, my lord. This is the explanation given to the Lokayukta. My lord, page 22, my lord, in the middle. ನಾನು ನಿಗಮದಲ್ಲಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿದ್ದು ನಾನು ಪ್ರತಿ ವರ್ಷವೂ ನನ್ನ ಆಸ್ತಿ ಮತ್ತು ದಾಯಿತ್ವದ ವಿವರವನ್ನು ನಮ್ಮ ಮೇಲಧಿಕಾರಿಗಳಿಗೆ ಸಲ್ಲಿಸುತ್ತಾ ಬಂದಿರುತ್ತೇನೆ ಮತ್ತು ಪ್ರತಿ ವರ್ಷವೂ ನನ್ನ ಪತ್ನಿಯ ಮತ್ತು ನನ್ನ ಆದಾಯ ತೆರಿಗೆ ಸಲ್ಲಿಕೆ ಆದಾಯ ಇಲಾಖೆ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ. ಆ ಸದರಿ ಪ್ರತಿಯನ್ನು ಮಾಹಿತಿಗಾಗಿ ಮಾನ್ಯ ಅವಗಾಹನಕ್ಕೆ ಸಲ್ಲಿಸಿರುತ್ತೇನೆ. Now the charge is, my lord, I have not obtained prior permission. The rule 23 says, my lord, there is previous knowledge. Prior permission is not mandatory.
No, let us.
Lord, I have sought for an interim prayer. Lord, I had the
No.
Lord, in the earlier proceedings, Lord.
No, sir. That was on a different cause of action. Now it is different. Who appears for this respondent corporation?
Corporation, my lord, on the last occasion. Devendrappa had appeared.
Learned Counsel Shri
H. Devendrappa.
H. Devendrappa. Who appeared for the first respondent corporation in the earlier round of litigation is directed to take notice for the first respondent corporation. Learned Counsel Shri ಇನ್ನೊಂದು ಹೆಸರು ಹೇಳಿದ್ಮಲ್ಲ ಲೋಕಾಯುಕ್ತ
ವೆಂಕಟೇಶ್ ಅರ್ವಟ್ಟಿ ಮೇಡಮ್.
ಇನ್ನೊಂದು ಯಾವ್ದೋ ಹೇಳಿದ್ರು ಅಶ್ವಿನ್ ಹಾಲಾಡಿ. Learned Counsel Shri Ashwin Haladi is directed to take notice for response number 2 and 3. Learned Counsel for the petitioner is directed to serve 2 sets of copies of the petition along with annexures on the Learned Counsel for the respondent. They released this matter on 10th of March. Learned AGA takes notice for response number 1 and 2. Issue notice to respond number 3. Learned Counsel for the petitioner is directed to serve a copy of the petition along with annexures on the Learned AGA. Next para. The selection and appointment of the third respondent to the post of Anganwadi worker at the Lakkasandra Anganwadi Center, Kasba Hobli, Turvekere Hobli, Turvekere Taluk, Tuмкuru district shall be subject to the final outcome of this petition. Senior resident.
promotion is due not in April 2022. In the midst of modified respondent is due. Not a notification was get. Kindly see. Plus, calling the direct recruitment check code. And if they get paid 9 more, but if you get it, you get 6, 7 plus 6 more. That is the only one code available more. But if this code is filled up by where direct recruitment law, plus I will be declared, plus I will be promoted law, plus I am supposed to be promoted plus in the April law. Plus my candidate.
You are appointed. Where is your appointment order?
And if you see page number 22. 47 to 2004 is the appointment order. And if you see page number 22.
Senior resident.
Yes, ma'am. Thereafter, plus I have been promoted. Plus I kindly plan to page number 24. Promoted to.
How can you say if there is a provision for direct recruitment to the post of professor? Don't appoint at the enkelak bartane.
I'm not saying so.
Mate?
Only one code is available.
Irbodu.
And two for promotion in
Sir, but you are yourself saying there is a provision for direct recruitment to the post of professor.
There are so many anomalies. Therefore, the NC plus has come to the guidelines. Plus regarding any teachers eligibility qualification, medical education law.
Anyone appears for this respondent institution? Any advocate who appears? You appear Akira. Learned counsel Srimati Sumana Baliga, who is present in the court, takes notice for the respondent institution. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent. Release this matter on 10th of March. Please take instructions. Young sir, you yourself are saying that there is a provision for direct recruitment.
There is anomaly. And due to this
anomaly?
Due to this anomaly, the NMC has issued a guideline. Teachers eligibility qualification medical institutions. Now this guidance is not followed.
You take instructions. Let it come up. No, sir. No.
Lakshmama has been.
No, nothing. Nothing.
It is subject to result. It is subject to result.
Yeah, next para. If there is any appointment made by the respondent institution pursuant to the impugned notification at annexure A, comma A and B, comma the same shall be subject to the final outcome of this. In respect of the post of professor, associate professor, Department of Pediatrics. Yes. ಏನಮ್ಮ ನೀವ್ ಹಿಂಗೆಲ್ಲ ನೀವೇ ಟೈಮ್ ಕೊಡ್ತೀರಾ? ಇಷ್ಟದ ತಗೊಳ್ಳಿ ಮ್ಯಾಟ್ರು. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಇಸ್ ದಿಸ್ ದಿ ವೇ? ಪಾಸ್ ಓವರ್. You have directed issuance of notice to the respondent. Non-filing of process memo. Served a copy alla. We are directed issuance of notice. Yesterday. ಅದಕ್ಕೆ ಮತ್ತೆ ಅವ್ರು Learned Counsel Srimati Sumana Palika undertakes to file wakalat for respondent number 1. Office is directed to show the name of Learned Counsel Sri NKT for respondent number 2. List this matter along with the revision petition number 383 of 2021. A date has been given there. On when do you want the matter? Monday. 8th of March. 8th of March.
Petitioner.
Not appearing for respondent number 2 in this matter, my lord.
2017. Has filed a memo seeking or retiring from the case. What is this? Karnataka Residential Education Institution Society. You are appearing. Who is appearing for respondent number 2?
Please, my lord. I'm appearing for respondent number 2, my lord.
What is your submission?
My lord, this case is mainly about the service weightage, my lord. The petitioner has scored the below service weightage, my lord. There is an office objection raised that the copy is not been served. The statement of objection copy is not been served to the petitioner counsel. The due course of the day will serve the copy, my lord.
He is still working with you?
No, my lord. My lord, we need to seek the details from the institution itself, my lord. We'll submit for the lordship. A week time may be granted, my lord.
How will you serve this copy to him?
Not there is is mentioned in the petition. We'll go to the office itself and we'll serve the copy, my lord.
Yav officer? You are saying he is not working with you?
My lord, to the petitioner counsel, my lord.
Petitioner counsel retire ಆಗಿದ್ದಾರೆ ಅದಕ್ಕೆ petitioner ಹೆಸರು ತೋರಿಸಿರೋದು.
I apologize, my lord. I'll seek the instruction and I request for a day's time, my lord.
Matter is called out. There is no representation for the petitioner. So it is seen from the order dated, from the daily order dated 7/8/2017 that the Learned Counsel Sri V.S. Ravindra Hulla, who was earlier on record for the petitioner, sought to retire from the case and permission was granted by this court. Stop. Four weeks time was granted to the petitioner to engage a counsel of his choice. Stop. Nevertheless, no alternative arrangement is made. Full stop. Release this matter on 10th of March 2022. Full stop. If there is no representation for the petitioner on the next date of hearing, this writ petition will be dismissed.
Yes, my lord.
Point number 3. Huh? ತಗೋಬೇಕು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು. At the request of learned counsel for the petitioner, a week's time is granted for filing appropriate application for taking steps in respect of respondent number 3. ಇವರು ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಬ್ಯಾಂಕ್ ಸುಮ್ಮನೆ ಸರ್ಡ್ ಅಂತ ಹಂಗೆ ತೋರಿಸಿದಾರಲ್ರಿ. ಈವನ್ ದೇ ಹ್ಯಾವ್ ಆಲ್ಸೋ ನಾಟ್ ಅಪಿಯರ್ಡ್. ಮತ್ತೆ 2019 ಮ್ಯಾಟ್ರ್ ಈ ತರ ಆದ್ರೆ ಐ ಡೋಂಟ್ ಥಿಂಕ್ ವಿ ವಿಲ್ ಬಿ ಏಬಲ್ ಟು ಗಿವ್ ಎನಿ ರಿಲೀಫ್ ಟು ಯು. You should ensure that the bank is represented. Yes. Rectification, statement of objection. Award ಅಂದ್ರೆ ಏನು?
Award is holding that the dismissal order passed by the management of the corporation.
ಹಾ ಆಯ್ತು. ಹಾ
So therefore, 2007 onward, the original employee was entered for years of salary up till date of contract.
Ah.
He was not,
when was that award passed?
yes, election day is the award. It is dated 9th February 2007.
2007.
Yes.
ಹಾ
Kindly go to page 18.
ಹಾ ಅಲ್ಲಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ನೀವು?
ಅಲ್ಲಿಂದ ಏನು ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ appeal ಆಗ್ತದೆ. appeal ನ stay ತಗೊಳ್ಳಿ.
Stay was granted.
By the Karnataka Appellate Tribunal.
ಹಾ
The appeal can be dismissed as per the same from election week.
ಹ್ಮ್
Page 23. Therefore, in the award passed by the assembly of Congress.
ಹ್ಮ್
Then the petition is filed.
ಹ್ಮ್
Report from the court by the order is granted. So therefore, we are entitled to execute the decree.
ಹ್ಮ್
Now we have filed the execution petition before the assembly petitioner.
ಹ್ಮ್
So far, no action has been taken.
ಹ್ಮ್
So execute the decree.
let us see the provision.
Please.
They have quoted some other provision.
That is not applicable to the
ಹ್ಮ್
This is the execution petition which I have produced along with the
ಹ್ಮ್
That is
execution petition.
number 3 of 2017.
ಹ್ಮ್
The appeal before the Karnataka Appellate Tribunal came to be dismissed on 28th January 2017. Immediately thereafter, this execution petition is filed.
ಹ್ಮ್
It is the duty of the authority under the Cooperative Societies Act and rule to execute. There is no other way. I have to go before the establishment of Cooperative Societies, seek for the execution of the award. Because he could not be reinstated on account of the death. Monetary benefits they are entitled to. And it is the management which brought us on record as the legal representative of the disciplinary.
ಹ್ಮ್ yes madam, what do you have to say?
I approve this matter to be Writ petition. Present writ petition which is talking about which they had filed. In that time, respond number 3 and 4. And my first writ petition 52/946. Petition here. Yes. Petition submit. Delinquent employee herself admits regarding the misappropriation of funds. Rightly, there was an inquiry conducted. Audit report was also produced. All the documents relating to her admission regarding misappropriation of funds herself was considered. That's why they have dismissed her. Now, Your Honors, after dismissal,
But both the authorities have held that there was no inquiry held.
both the authorities did not consider, Your Honors, the very fact my response which was already placed on record. They did not consider
ಹಂಗ್ ಬರೋದಿಲ್ಲಮ್ಮ.
my humble
You
submission
have to
was-
hold an inquiry.
Yes, Your Honor.
You have to hold an inquiry.
Very well, Your Honor.
You have to confront that letter, or if she has given it in writing, that had to be confronted. And if she agrees, only then you can say, yes, she has admitted, and therefore we are proceeding with pass order.
Yes, my
ನೀವು ಅದೆಲ್ಲ ಏನು ಮಾಡಿಲ್ಲ. So therefore, both the authorities are right when holding. There was no inquiry held.
My lords, that's the reason why, my lords, inquiry was conducted. I've already produced the inquiry report, as well as they have told her to appear because on particular date where she did not appear. And based on a non-appearance also, they have given once and twice reminder for her appearance, my lords, because she did not finally appear.
So therefore, you
Based on an audit
could have made a statement before the authority that we please remand the matter. We will hold an inquiry and then come back to you.
very well, everything was
ನೀವು ಅದನ್ನ
conducted.
ಮಾಡ್ಲಿಲ್ಲ.
My lords, everything was conducted based on the audit report and all the inquiry which was done. Now, Your Honors, when they have subsequently filed a writ petition based on my writ petition, I don't know who they are because she was not married and neither they
question.
want the alarms on record.
You need not go into that question now.
my lords, before the authority itself, we had raised this question, your lords, and that was not considered at all. That's the reason why we were forced to file a 2017 writ petition, your lords, which was pending. Subsequently, the ARS rightly rejected the execution petition, my lords. That's my humble submission. The ARS.
Where is it rejected?
My lords.
Where is the order?
No, before the registrar, he rightly rejected that petition, or execution petition.
Where is the order of rejection, madam?
They have produced it, my lords.
Where?
No.
This is only, it is only an information given under the Right to Information Act. Where is the order rejecting their execution petition?
I shall look into that, my lords. That was in Kannada. I shall look into that, my lords.
Your repetition is liable to be dismissed. We will dismiss your.
No, my lords. My humble submission, my lords. I shall produce those documents.
What documents, Amma?
Documents is all. I just look into those documents, your honor.
What documents, sir?
Which the authority AR has already rejected.
It is very clear that you have not held an inquiry.
My lords, it is not
In
that
the
we
inquiry.
have, no, my lords. First petition, we have produced records saying that the audit report was already on record, inquiry was conducted, and opportunity was given for the delinquent. And not only that, my lords, she herself admits in writing that to deduct her from her remaining salary, the misappropriation of funds, my lords.
Adannamma, if she has given something in writing, that should have been put to her in the inquiry, and if she admits there also, yes, ನಾನು ಆಗಲೇ ಕೊಟ್ಟಿದ್ದೀನಿ writing ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
During the pendency of after that she died, my lords. My lords, the date may be fixed for final hearing of this matter, my lords. Now, since both the matters may be clubbed together, a final hearing for this matter, I shall also seek instructions. Like my lords suggested.
What instructions, Amma?
I shall seek instructions on this matter, my lords. Like my lords kindly suggested that where is the order for rejection by the registrar, your lords. I shall seek instructions and finally action this matter. Pretty much the after tomorrow, my lords.
All right. Barkal.
Management which brought us on letter page 23 of the legal representative. This perspective is no longer relevant. The contention cannot be argued before the court. They who brought us on letter.
One minute. Petition number 52946 of 2017 is filed by the town Vividodesha Sahakari Bandara Niyamita, a registered cooperative society. Calling in question the orders of the Assistant Commissioner, Assistant Registrar of Cooperative Societies, and the Karnataka State Appellate Tribunal. Which by which the orders passed by the society dismissing the dismissing Srimati Jaganmata Devi, who was an employee of the society.
Registered cooperative society. Question the orders of the assistant tribunal by which it was passed by the society.
Pause. Set aside. Stop. On the other hand, writ petition number 8736 of 2020 is filed by the persons claiming to be legal heirs of Srimati Jaganmata Devi, aggrieved by the inaction on the part of the Assistant Registrar of Cooperative Societies in not passing any orders in respect of the execution petition in CEP number 3/2017-18 filed by the petitioner, seeking the execution of the award passed by the Assistant Registrar of Cooperative Societies in proceedings bearing number 2/2000-2001, dated 9th of February 2007, wherein it was directed that Srimati Jaganmata Devi should be reinstated into service and along with all back wages. Next paragraph. During the course of the argument, learned counsel for the Cooperative Society submits that the Assistant Registrar of Cooperative Societies had in fact dismissed the execution petition. However, a copy of the said order is not available. For contra, learned counsel for the petitioners has furnished a copy of information provided by the Chief Information Officer of the Registrar of Cooperative Societies on 9/3/2020, at annexure H, to substantiate his contention that no such orders have been passed. Stop. Next paragraph. At the request of learned counsel for the Cooperative Society, release this matter on 7th of March. Yes.
Yes.
Matters called out. There is no representation for the petitioner. However, week's time is to take fresh steps in respect of respondent number 6. Yes.
Yes, one second.
Assistant?
he was considered to be eligible, and accordingly, his name was found in the list of the candidates selected and placed for the TPC. TPC was conducted on 23/7/2009.
2009.
Yes, 2009.
Ah.
They did not issue orders of promotion, but on 21/8/2009, they got online options regarding posting. Regarding posting, but they did not issue orders of promotion. Therefore, my lord, I told you before, in the lord agreeing the bill number 85871-873 of 2009, Section E, page 43. Here, the Lord, several requirements were passed, protecting my interest. Ultimately, the Lord, we were in 4 in number area. This court, the Lord, directed the respondents, the Lord, by way of interim order, page 47, directed them to consider the Lord the case of the petitioner along with others initially. Page 47.5. I'm only pointing out the Lord, the interim order passed in that petition, which was the basis for disposal of it.
Yenanta, what was the interim order?
Interim order was in the nature of first initially on 23/11/2009, page 46. Response are permitted to go ahead with the promotion to the post of accounts officer, keeping 3 posts of the petitioners vacant. She is also 6 times so. Now next order 4/2009. Second, she is also the rate post for the corrective sufficient that the clarification is necessary for the interim order election issued on 23/11/2009. It is hereby clarified that the respondent petitioner shall proceed with the consideration of all the candidates eligible for promotion, including the petitioner, and if found entitled for promotion, may issue necessary orders. If there are no unresolved slots for the petitioners to be accommodated in the promotion, in that way the response will assign reason and keep 3 posts vacant for them. Thereafter, on 2009, if you was published in our specific paras 1 and 2, in compliance with the order dated so-so 2009, so-so 11% of the respondent memo dated 14/12/2009 stating that 99 eligible AAOs were considered for filling up of 25 clear vacancies as on 30/11/2009, out of which the GTC has cleared a 22 posts from MS, which 11 belong to general merit, 9 to scheduled caste, and 2 to scheduled tribe, while the 2 posts have not been filtered from the direction. In addition, it is stated that the names of the officers are found at serial number 26, 29, and 31 in the scheme of list, and therefore do not fall in the zone of consideration. We have questioned in this court series on that scene number 22, she 23 by name Sri Rabi would get a promotion as against 2 vacancies, while another vacancy would go to the study caster, who is serial number 87 by name P. Shivana. She loaded 100% for the petitioners contends that the question of backlog vacancies would not arise as on 23/7/2009. Since on that day, the so-called candidates belonging to study caste and study tribe were still born and were not eligible for promotion, while petitions and others had been cleared by the DPC and were awaiting orders of promotion. This submission will run for the petitions to the question that precisely needs to be decided in this petition, and therefore, at this stage, without getting the expression on its merit, it would be unfair if the 3 vacancies are kept open without allowing the promotions to be given effect. The promotions to the 25 posts will be effective. It is the needless to state would be subject to the decision of the petition. In addition, it would also be needless to state that if the petition certificate are to be entered to promotions.
ಆಯ್ತು ಬಿಡಿ, ಆಯ್ತು. ಈಗ ಫೈನಲ್ ಏನಾಯ್ತು? ಅದಾಯ್ತು ಬಿಡಿ, ಅದು ಹಳೇದು ಆಯ್ತು. ಇನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 3, ದ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಏನಾಯ್ತು?
They were promoted on 1/2/2011. They were promoted. Now, should have been promoted from 21/8/2009. I will regard to the 80 models called the caste because the respondent management 1 and 2 are cleared by directed to consider the claim of this for retrospective promotion from 2009 and as expediency as per the daily event of 6. This order may not actually nothing to do with I went on giving representation. Now, my lord, after they come up with
Allah, sorry. When this matter was disposed of, you read out the interim orders. You read out the interim orders now. What happened in the final disposal? Now, what is
now it is got penalty. The petitions are now promoted as accounts officers. The only grievance of the petitions is that they should have been promoted in the 2009. Having got the interim orders passed by this court, as said above, the respondent management 1 and 2 are hereby directed to consider the claimant petitioners for prospective promotion with effect from 21/8/2009. And as now, what happened was on 23/7/2009, the DPC was read. And on 21/8/2009,
sir, why are you going back on that one? This order was passed on 27th of June 2012, directing them to give retrospective effect. ಆಮೇಲೆ ಏನಾಯ್ತು?
now there are the investment around page
59. 2000. What were you doing then? What were you doing?
But even without this partnership was not they said that the patients are being considered and will be considered and they will be given promotion.
Madam, you have not challenged that order.
No, my lord.
You have not challenged this order dated 27th of June 2012.
Between 2012 to 2020, there were a number of litigations before this honorable court, and finally, which landed up in the apex court. Until today, regarding seniority, there is a big question mark, and litigations are in progress, my lord. But my learned friend is not correct when he says that on 23/7/2009 we have given promotions. We have not given promotions to anybody, either for the 21 vacancies that existed, or subsequently another 3 more vacancies came up, and altogether it became 25. Neither was petitioner coming under the 21 vacancies nor under the 25 vacancies. Subsequently, when petitioner came up, when petitioner came with the list on to in the year 2011, we have granted. When there is no vacancy and when petitioner cannot be filled up, how can we give retrospective vacancies, retrospective promotion? Last year, in fact, my lord had asked for a summary, hence I made a summary. Why we could not consider on 23/7? What happened after 23/7? And why petitioner could not be filled up between the 25? Roster was applicable. Out of the 22 vacancies, only 11. It is not the case of the petitioner that one of his juniors were promoted. All the 21, for all the 21 people, we have not given promotion at all because there was by-elections and the model code of conduct was in operation. So we could not give. In fact, not even in 2009. In the year 2010 only, promotions were granted. For the 21, subsequently, which became 25. So there is no fault on the corporation at all. We have not given promotions to anybody. And now asking for retrospective promotions from 21/8 is not applicable because we have not given promotions to anybody at all in August 2009. We gave promotions only in the year 2010, that too after the disposal. In 2010 only, he knew, my lord, he is not coming within the selected people of 21 nor selected people of 25. Clearly in the previous petitions, in the first round of litigations, it is made amply clear that he was not falling within the 25 people. That is why there was only a direction given by this honorable court to consider his representation, my lord. And in Annexure L, my lord, if we go through Annexure L, it is amply clear, my lord. Everything will be following.
Annexure
L, my lord, which is now challenged. 7th March 2020 at page number 29, my lord. First.
Please read the second page. I have read the first page.
Yes,
please read the second page.
All right. Page number 60, it starts from ನಿಗಮದ R&P ನಿಯಮಾವಳಿ ಅನ್ವಯ ದಿನಾಂಕ 29/7/2002
ಶ್ರೀ ಜಿ ರಾಮ ಸಹಾಯಕ ಲೆಕ್ಕಾಧಿಕಾರಿ ಅವರ ಜೊತೆಗೆ ಇನ್ನೂ ಹಲವರು ಲೆಕ್ಕಾಧಿಕಾರಿ ಹುದ್ದೆಗೆ ಬಡ್ತಿ ಹೊಂದಲು ಅರ್ಹರಾಗಿರುವ ಪ್ರಯುಕ್ತ ಅವರುಗಳ ಮಾಹಿತಿಯೊಂದಿಗೆ ಮರುಮಂಡಿಸುವಂತೆ ದಿನಾಂಕ 25/8/2009 ನಡೆದ 27ನೇ ಇಲಾಖಾ ಪದೋನ್ನತಿ ಸಭೆಯಲ್ಲಿ ನಿರ್ಣಯ ಕೈಗೊಂಡು ಸಭೆಯನ್ನು ದಿನಾಂಕ 31/8/2009 ಮುಂದೂಡಲಾಗಿರುತ್ತದೆ. ಈ ಮಧ್ಯೆ ಶ್ರೀ ಜಿ ರಾಮ ಹಾಗೂ ಇತರರು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನಿಗಮದ ವಿರುದ್ಧ ರಿಟ್ ಅರ್ಜಿ ಸಂಖ್ಯೆ ರಲ್ಲಿ ದಾವೆ ಹೂಡಿರುವುದಕ್ಕೆ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 4/2/2009 ಈ ಕೆಳಕಂಡಂತೆ ಮಧ್ಯಂತರ ಆದೇಶ ನೀಡಿರುತ್ತವೆ. ಇಟ್ ಇಸ್ ಹಿಯರ್ ಬೈ ಕ್ಲಾರಿಫೈಡ್ ದಟ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ದಿನಾಂಕ 4/2/2009 ಆದೇಶ ಅನ್ವಯ ದಿನಾಂಕ 25/8/2009 ಜರುಗಿದ ಇಲಾಖಾ ಪದೋನ್ನತಿ ಸಮಿತಿ ಸಭೆಯಲ್ಲಿ ದಿನಾಂಕ 30/11/2009 ಹಾಲಿ ಖಾಲಿ ಇರುವ 25 ಹುದ್ದೆಗಳಿಗೆ ಎದುರಾಗಿ 22 ಹುದ್ದೆಗಳಿಗೆ ಸರ್ಕಾರದ ದಿನಾಂಕ 24/6/97 ರೀತಿಯ ರೋಸ್ಟರ್ ಹಾಗೂ ಅಧಿಕ ರೋಸ್ಟರ್ ಬಿಂದುಗಳನ್ನು ಅಳವಡಿಸಿ ಪದೋನ್ನತಿ ನೀಡಲು ತೀರ್ಮಾನಿಸಿ ಪದೋನ್ನತಿ ಸಮಿತಿಯ ನಿರ್ಣಯವನ್ನು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಗಮನಕ್ಕೆ ತರಲಾಗಿತ್ತು. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ದಿನಾಂಕ 14/2/2009 ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶ ನೀಡಿರುತ್ತದೆ. In that view of the matter, I think it appropriate to direct the respondent petition to fill up the 3 other vacancies forthwith and list this petition in preliminary hearing during the first week of January 2010. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ದಿನಾಂಕ 14/12/2009 ಆದೇಶ ಪಾಲಿಸುವ ಸಲುವಾಗಿ ದಿನಾಂಕ 3/2/2010 ಜರುಗಿದ ಇಲಾಖಾ ಪದೋನ್ನತಿ ಸಮಿತಿ ಸಭೆಯ ನಿರ್ಣಯದಂತೆ ದಿನಾಂಕ 31/12/2009 ಅಂತ್ಯಕ್ಕೆ ಬ್ಯಾಕ್ಲಾಗ್ ಒಳಗೊಂಡಂತೆ ಖಾಲಿ ಇದ್ದ 26 ಲೆಕ್ಕಾಧಿಕಾರಿ ಹುದ್ದೆಗಳಿಗೆ ಸರ್ಕಾರದ ದಿನಾಂಕ 24/6/97 ಆದೇಶ ರೀತಿಯ ರೋಸ್ಟರ್ ಮತ್ತು ಅಧಿಕ ರೋಸ್ಟರ್ ಬಿಂದುಗಳನ್ನು ಅಳವಡಿಸಿಕೊಂಡು ನಿಗಮದ ದಿನಾಂಕ 4/9/2010 ಅಧಿಕೃತ ಜ್ಞಾಪನ ಸಂಖ್ಯೆ ರಲ್ಲಿ ಸಹಾಯಕ ಲೆಕ್ಕಾಧಿಕಾರಿ ಹುದ್ದೆಗೆ ಪದೋನ್ನತಿ ನೀಡಲಾಗಿದೆ. ಆದರೆ ರಿಟ್ ಅರ್ಜಿದಾರರಾದ ಶ್ರೀ ಜಿ ರಾಮ ಹಾಗೂ ಇತರರು ಸಹಾಯಕ ಲೆಕ್ಕಾಧಿಕಾರಿ ಪದವೃಂದದ ಹುದ್ದೆಯಿಂದ ಲೆಕ್ಕಾಧಿಕಾರಿ ಪದವೃಂದದ ಹುದ್ದೆಗೆ ಪದೋನ್ನತಿ ಹೊಂದಲು ಅರ್ಹರಾಗಿದ್ದಾಗಿಯೂ ಸಹ ಜ್ಯೇಷ್ಠತೆ ಮತ್ತು ರೋಸ್ಟರ್ ನಿಯಮಗಳ ಅನ್ವಯ ಈ ಮೇಲೆ ವಿವರಿಸಿದ 26 ಹುದ್ದೆಗಳ ಒಳಗೊಂಡಿರದ ಪ್ರಯುಕ್ತ ಇವರನ್ನು ಪದೋನ್ನತಿಗೆ ಪರಿಗಣಿಸಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಶ್ರೀ ಜಿ ರಾಮ ಸೋಂಸೋ ಲೆಕ್ಕಾಧಿಕಾರಿ ಕಾವೇರಿ ಬೆಂಗಳೂರು ಆದ ನಿಮಗೆ ನಿಗಮದ RNP ನಿಯಮ ಹಾಗೂ ನಿಬಂಧನೆಗಳ ಅನ್ವಯ ದಿನಾಂಕ 1/2/2011 ಲೆಕ್ಕಾಧಿಕಾರಿ ಪದವೃಂದದ ಹುದ್ದೆಗೆ ಪದೋನ್ನತಿ ನೀಡಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ದಿನಾಂಕ 21/8/2009 ಪೂರ್ವಾನ್ವಯವಾಗಿ ಪದೋನ್ನತಿ ನೀಡುವಂತೆ ಕೋರಿದ ದಿನಾಂಕ 9/5/2019 ಮನವಿಯನ್ನು ಈ ಮೇಲೆ ವಿವರಿಸಿದ ಕಾರಣಗಳಿಂದ ಪರಿಗಣಿಸಲು ಪ್ರಸ್ತುತ ಅವಕಾಶವಿರುವುದಿಲ್ಲ ಎಂದು ತಮ್ಮ ಗಮನಕ್ಕೆ ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ.
In the last paragraph of Act 360 that they have given promotions without including the roster on 9/4/2010. When 9/4/2010 persons who were entitled for promotion, they were not qualified as on 31/7/2009 itself. They were not. They were not entitled eligible for promotion on 31/7/2009 itself, because on 23/7/2009 when the DPC met and my names were, our names were suggested, then we were found qualified even according to them. Even according to, if I am not eligible, as on 23/7/2009, maybe I am okay. But as on 23/7/2009, my name was suggested to be DPC, and DPC has been approved. That's what they wanted to do. They are supposed to do.
It was not finalized. Everything was happened, but it was not finalized.
When that is on 21/8/2009, there was no reason for online options. 21/8/2009, they got for online options only to ensure that their promotion orders. Online options is exercising their option with respect to posting, which place or which office you want. Just like as you did 21/8/2009, they themselves called online options. The requisition will not get to be disposed of. Thereafter, will not on 27/6/2001. But in the meanwhile, they have given promotion 2010 has undertaken by them.
Sir, but for 8 years you have kept quiet. Only at the fag end of your.
For
career.
Consent, all
Just
that.
because, just before you are going to retire, you have filed this.
ರಿಟೈರ್ ಆಗೋದು ಆಗೋಯ್ತು.
ಆದ್ಮೇಲೆ ಹಾಕಿರೋದಾ?
ಇಲ್ಲ ಮೊನ್ನೆ ರಿಟೈರ್ ಆಗಿ 28 ರಿಟೈರ್ ಆಗೋದು.
But you have mentioned your age as 59. You have mentioned your age as 59.
He was not retired.
Correct, but that was in 2020. This writ petition was filed on 14th of July 2020. Adene. In 2021 itself, he must have retired. Adenge.
ಅಲ್ಲ ಅಲ್ಲ year
Adene.
Lord, he was not eligible neither on that day, not last week. He was not at all eligible, my lord. Illa andre, suppose, my lord, if it was his contention that only he was targeted and he was not given, then they had a case. All the 25 people were not promoted at all. Then how can he be? They have made allegations that just to accommodate others, we have not convened enough. Model DPC.
That information is available in the last paragraph at page number 69. Adalla, page number 59, first page of the annexure. Last paragraph.
ವಿಧಾನಸಭೆಗಳ ಉಪಚುನಾವಣೆ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನೀತಿ ಸಂಹಿತೆ ಜಾರಿಯಲ್ಲಿದ್ದ ಶ್ರೀಯುತ ಭಾರತ ಚುನಾವಣಾ ಆಯೋಗದ ಸಂಖ್ಯೆ 17/2009 ನಿರ್ದೇಶನ ಮೇರೆಗೆ ಪದೋನ್ನತಿಯನ್ನು ತಡೆ ಹಿಡಿಯಲಾಗಿದೆ.
ಎಲ್ಲಾರ್ದು ತಡೆ ಹಿಡಿಯಲಾಗಿತ್ತು. ಆಮೇಲೆ ಆಫ್ಟರ್ ದಿ ಎಲೆಕ್ಷನ್ಸ್ then they have given effect to that. So whatever benefit others were given, the same benefit has been given to you also. Whatever benefit is given to others is given to you also. You have not been targeted as per what you are saying. ನೀವು ಬೇರೆಯವ್ರಿಗೆ ಏನ್ ಬೆನಿಫಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆ ಬೆನಿಫಿಟ್ ಫ್ರಮ್ ದಿ ಡೇಟ್ when you become eligible they have given it to you also. ಹೌದು.
On 23/7/2009, I have been found to be eligible along with two others for being promoted. They have taken decision to promote it. In person, they are allowed.
Howdu sir, but those submissions were made before this court when that earlier matter was going on.
It was recorded.
Idalla sir, earlier avaga when your earlier petition was pending. Correct. Adralli interim orders were passed recording the submission of the learned counsel who was then appearing for the corporation. It is no doubt true that these dates are given there. Adre the fact is that because of this elections and the code of conduct, no promotion was given. What was given was only subsequently. Along with the others, your promotion is given to you also. You have not been singled out.
My grievance is that as on 31/7/2009, my lord, others were not eligible as on that day. 31/7/2009, the persons may not who belong to reserved category. I'm not a reserved candidate at all. As on 31/7/2009, if the persons may not seeking reservation, where to be not eligible as of 27/2009, I am on this system to be punished because they give the account claim in their endorsement not below. However, 9/4/2010 ಈ ಅಧಿಕೃತ ಕಾಂಪಿಟೇಷನ್ ಸಹಾಯಕ ಲೆಕ್ಕಾಧಿಕಾರಿಗಳಿಗೆ ಪದೋನ್ನತಿ ನೀಡಲಾಗಿದೆ. 2010 ಕೊಡ್ತಾರೆ ಎಲ್ಲರೂ ಕೊಡ್ತಾರೆ. My case is that as on 22/7/2009, I was eligible to consider for promotion. They deliberated, denied, they postponed.
Have you filed your objection?
Yes, my lord, I have filed my statement of objections. Lord, when the next DPC was convened, along with the additional vacant post, we have considered all those who, as on that date of DPC, were eligible to be considered. ಬರೀ ಅಡಿಷನಲ್ ಪೋಸ್ಟ್ ನ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು, ಯಾರು ಎಲಿಜಿಬಲ್ ಇಲ್ವೋ ಅವ್ರನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು ಅಂತ ಆಗೋದಿಲ್ಲ. Whoever is eligible as on the date of the next DPC, all of them were considered, and that is why 21 ಇದ್ದಿದ್ದು 25 ಆಯಿತು.
Please read from paragraph number 5 of your statement of objections.
It is submitted that 26th Departmental Promotion Committee for existing 21 vacant posts of accounts officer were held on 23/7/2009, and petitioner along with other assistant accounts officers were considered for promotional posts of accounts officer. That due to by-elections to the state legislature, assembly and model code of conduct coming into force under the letter of Election Commission of India bearing so and so dated 17/7/2009, the promotion orders had been withheld. That in the meanwhile, 3 more vacancies of accounts officer arose due to promotion of accounts officer to the post of deputy controller of accounts by notification dated so and so dated 29/8/2009. That as per the government of Karnataka OM number DPAR 5 SRC 84 dated 1985, adopted by board order number KPTCL E3 so and so dated 21/12/2001, the cases of all the officials in the current selection list who had not been promoted as on the date of the next meeting of the Departmental Promotion Committee should again be placed for consideration of the committee. Therefore, all the officials who were eligible for promotion as on 29/7/2009 were also placed before the DPC held on 31/8/2009. That there were 15 SC and 5 ST candidates. That there were 81 SC and 5 ST backlog vacancies. That as per government order number so and so dated 3/2/1999, read with amendment dated 13/4/1999, adopted by the board, the promotions of the person belonging to the SC and ST will continue to operate until the existing backlog is cleared. However, due to non-receipt of annual performance report of few assistant accounts officers, the DPC was postponed to 3/9/2009. The process of obtaining options from officials was being done in preparation to match the requirements of candidates for suitable posting wherever possible. It is submitted that promotions were effected to few of the officers, but petitioner and others, even though eligible, could not be promoted due to the operation of backlog vacancies for promotion and also due to seniority and roster rules as per the government orders in the matter. That subsequently petitioner was promoted to the post of accounts officer on 1/2/2011. The petitioner and others had filed WP number so and so disposed of on 27/6/2012, whereunder there was a direction to consider the representation of the petitioner and others for promotion with retrospective effect, that is from 21/8/2009. It is submitted that the representation was considered by the corporation and an endorsement came to be issued dated 7/3/2020, whereunder the request of the petitioner came to be rejected by annexure L agreed by the same. The petitioner is before this honorable court seeking for the quashing of the same. It is submitted that the Honorable Apex Court in Union of India and others versus KK Vadera and others, AR 1990 SC 442, in para 5 has observed as under. We do not know of any law or any rule under which the promotion is to be effective from the date of creation of the promotional post. After a post call vacant for any reason whatsoever, a promotion to that post should be from the date the promotion is granted and not from the date on which such post was vacant. In the same way, when additional posts are created, promotion to those posts can be granted only after the assessment board has met and made its recommendations for promotions being granted. Further, it is submitted
That this should answer your grievance. ಮತ್ತೆ ನೀವೇನ್ ಕೇಳ್ತಾರ? ನೀವು what is it that you are asking? What is it that you are asking?
I am asking for promotion from the date I am found to be eligible even.
ಅದನ್ನೇ, that is the answer.
Promotion post all vacant. ಅದು additional post ಇದೆ. After post all vacant for any post, promotion that post should be from the date of promotion and not from the date on which such post all vacant. Post all vacant as on that day. As on that day, promotions were to be given.
ಅದನ್ನೇ, that is what, unless and until the DPC takes place and you are promoted. Correct. From that date only you will be eligible.
Yes, 2009
2009 ಇಂದ ಆಗಿಲ್ಲ. That is what you read it in paragraph number 5.
Then if that on 2009, the date on which they called for options.
That day also promotion.
Sir, called for options ಅಂತ ಆಗೋಯ್ತಾ? There has to be an order of promotion, sir. There has to be an order of promotion.
That is not done with
No, sir. See, you have not been singled out. You can't claim that you have been singled out and you've been given a different date of the benefit only from a subsequent date. There's nothing like that has happened.
That has happened because
No, sir.
on 31/7/2009, when the SCST persons were promoted, where I'm sorry, SCST persons were supposed to be promoted. They were not eligible as of that day. Even if they were to be promoted, my case would not go unconsidered. At least they should have been given the date cannot, and the DPs are said, or at least 21/8/2009, when online options were called, because we were informed eligible. They had taken addition to promoters. They had taken addition to promoters. It is not as if DPs are casually taken or that casually they have made them. No. On 21/8/2009, options were only for the purpose of assigning the posting order.
Just now he submitted that 23/7/2009 only they were eligible. Then after that 21/8/2009 under hege agutte. My lord, all these are procedures, my lord. 98 people were considered. 98 people were considered for only 21 posts. All the procedures were being followed. Only taking consent also will not suffice, my lord. As soon as he became eligible, we have granted.
ಸಹಾಯಕ ಲೆಕ್ಕಧಿಕಾರಿಗಳ ಹುದ್ದೆಯಿಂದ ಲೆಕ್ಕಾಧಿಕಾರ ಹುದ್ದೆಗೆ ಮತ್ತು HAS ಪರೀಕ್ಷೆ ಭಾಗ 2 ರಲ್ಲಿ ಉತ್ತೀರ್ಣರಾಗಿ ಸಹಾಯಕ ಲೆಕ್ಕಾಧಿಕಾರಿ ಹುದ್ದೆಗೆ ಹೊಂದಲಿರುವ ಅಧಿಕಾರಿ ನೌಕರರ ಪಟ್ಟಿ ಐಚ್ಛಿಕತೆಯನ್ನು OPR ಮೂಲಕ ಕಳಿಸುವ ಬಗ್ಗೆ 23/7/2009 26ನೇ ಇಲಾಖಾ ಪದೋನ್ನತಿ ಸಮಿತಿ ಸಭೆ ಜರುಗಿತ್ತು. ಅನುಬಂಧದಲ್ಲಿ ರಚಿಸಲಾಗಿರುವ ಅಧಿಕಾರಿಗಳು ಪದೋನ್ನತಿ ಹೊಂದಲು ಅರ್ಹರಾಗಿರುತ್ತಾರೆ. ಅವರುಗಳಿಂದ ಆನ್ಲೈನ್ ಪೋಸ್ಟಿಂಗ್ ರಿಕ್ವೆಸ್ಟ್ ಫಾರ್ಮ್ ಮೂಲಕ ಇಚ್ಛೆಯನ್ನು ತಿಳಿಸಲು ಸೂಚಿಸಿದೆ. ಆದ್ದರಿಂದ ಸದರಿ ನೌಕರರು 27/8/2009 ಶನಿವಾರ ಸಂಜೆ 5:30 ತಮ್ಮ ಇಚ್ಛೆಯನ್ನು ನೋಂದಾಯಿಸಬೇಕಾಗಿ ತಿಳಿಸಿದೆ. ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಎಲ್ಲ ಅಧಿಕಾರಿ ನೌಕರರ ಗಮನಕ್ಕೆ ತರಲು ಈ ಮೂಲಕ ಕೊಡಲಾಗಿದೆ. All of the persons there are.
Correct, sir.
My name is not at serial number 23 persons.
But they had to first fill up the backlog vacancies. So therefore,
as on 23/7/2009, if the persons may not eligible to be promoted, and they are to be promoted. I understand because of they having been qualified on 31/7/2009, that my case cannot be considered. That is where my first grievance is that when you find me eligible as on 23/7/2009, why did you promote me? That is the reason I approached number first point. Secondly, on 21/8/2009.
No, but
that is after 31/7/2009.
But but which is the law that would entitle you to seek to claim the benefit of the promoted post from the date you become eligible for promotion? Which is that law? They have pointed out to a judgment of the Honorable Supreme Court which says you are eligible to receive the benefits of that promoted post only from the date of your promotion.
When they have been considering persons who are not eligible as on that day, like main curiosity is the order of this.
Yen madadu, you didn't get it executed. You have come before this court after 8 years. Now when madakagutte?
But now they cannot come up with this. You can say that in 2020, the order is passed on to 2012.
Adene, that is the problem.
They will go on expecting some kind of report approach in the court. I don't want to say on that because there is a flaw in the immediate action to be taken. But anyway, my lord, as on you are supposed to.
Sir, but you are not able to point out to any law which would enable you to get the benefit of the promoted post from the date when you became eligible for promotion. Law illa. On the other hand, they have pointed out to a judgment of the Honorable Supreme Court which says you are eligible for that benefit only from the date of your promotion.
If my case had not been considered for in DPC along with the 23 others on 2009 or at least on 21/8/2009, this decision is only in respect of persons that is post falling vacant. Here, as on that day, the posts have been there.
Correct. It was there. Posts were there. There is no doubt about that. Posts were there. You were also eligible. Sorry, let us take it that you are eligible. But you are entitled to seek the benefit of that salary attached to that post. From when?
At least treatment is given because he struggled to get promotion during his life.
And 2011 only we have granted.
What the learned council is now saying is, I am not asking for the back wages, but for the purpose of fixation of the retirement benefits.
My lord, I have stated in my statement of objections also that it is submitted that pay is regulated for all employees based on their length of service and promotions from time to time. Pension is fixed based on the length of service and the pay at the time of retirement. So already his pay is at the level of accounts officer only because he retired as an accounts officer only, which was granted in the year 2011. Retrospective promotion cannot be granted at all because on that day there was no post vacant to fit him, my lord. If it was there, then we would have done. When there was no post at all, when there was no vacancy at all, then how can we grant him, my lord? If ಒಬ್ಬರಿಗೆ ನಾವು grant ಮಾಡಿದ್ರೆ, then again number of litigations will come. My lord, if his junior was granted promotion, then there would have been a right approved to him. But none of his juniors have been promoted at all. And as soon as he became eligible, we have granted him promotion. So it is not his case that there was no promotion. If we had not granted promotion at all, then definitely there would have been a right. ಯಾರಿಗೂ ಕೊಟ್ಟೇ ಇಲ್ಲ.
If fixation of pay would not matter much, it definitely will have an effect on it. 2009 promotion to the 11th promotion. I will find out by law.
ಅಲ್ಲ 2009 ಅಲ್ಲಿ ಯಾರಿಗಾದ್ರೂ ಕೊಟ್ಟಿದ್ರೆ submission would be correct, my lord. 2009 ಅಲ್ಲಿ ಯಾರಿಗೂ ಕೊಟ್ಟೇ ಇಲ್ಲ. 2010 ಅಲ್ಲೂ he was not eligible. 2010 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, 2009 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದ.
Why not me agree 2010 lord? The census certificate to the pay 60 lord. ಲೆಕ್ಕಾಧಿಕಾರ ರೋಸ್ಟರ್ ಬಿದ್ದುಗಳ ಅಳವಡಿಸಿಕೊಂಡು ನಿಗಮ ಅಂದ್ರೆ 26
2010 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಒಂಥರ ಬಾಟಮ್ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ದಿನಾಂಕ 19 ಆದೇಶ ಪಾಲಿಸುವ ಸಲುವಾಗಿ ದಿನಾಂಕ 3/2/2010 ಜರುಗಿದ ಇಲಾಖಾ ಪದೋನ್ನತಿ ಸಮಿತಿ ಸಭೆ ನಿರ್ಣಯದಂತೆ 31/12/2009 ಅಂತ್ಯಕ್ಕೆ ಬ್ಯಾಕ್ಲಾಗ್ ಒಳಗೊಂಡಂತೆ ಖಾಲಿ ಇದ್ದ 26 ಲೆಕ್ಕಾಧಿಕಾರಿ ಹುದ್ದೆಗೆ ಸರ್ಕಾರದ ದಿನಾಂಕ 24/6/97 ಆದೇಶ ರೀತಿಯ ರೋಸ್ಟರ್ ಮತ್ತು ಅಧಿಕ ರೋಸ್ಟರ್ ಬಿಂದುಗಳನ್ನು ಅಳವಡಿಸಿಕೊಂಡು ನಿಗಮದ ದಿನಾಂಕ 9/4/2010 ಅಧಿಕೃತ ಜ್ಞಾಪಕ ಸಂಖ್ಯೆ ಸೂಚನೆಯಲ್ಲಿ ಸಹಾಯಕ ಲೆಕ್ಕಾಧಿಕಾರಿ ಹುದ್ದೆಗೆ ಪದೋನ್ನತಿ ನೀಡಲಾಗಿದೆ.
ಕರೆಕ್ಟ್, ಹೌದು ಸರ್. No. Please understand. They had to first fill up the backlog vacancies. So therefore, that is what they are saying. A backlog 31/12/2009 ಅಂತ್ಯಕ್ಕೆ ಬ್ಯಾಕ್ಲಾಗ್ ಒಳಗೊಂಡಂತೆ ಖಾಲಿ ಇದ್ದ 26 ಲೆಕ್ಕಾಧಿಕಾರಿಗಳ ಹುದ್ದೆಗಳನ್ನು ಸರ್ಕಾರ ಮಾಡಲಾಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
when this was made on 31/7/2009, none of the SSC people were eligible. How separate vacancy recruitly, but now the regular vacancy. How put it as the number denied because as of 23/7/2009, much earlier to because they become eligible only on 31/7/2009. That's my complaint not to the commission. They became eligible. That's what I read a lot. That they were just born in that record, but they were not eligible as of 31/7/2009. If they are reconsidered for promotion from in their respective vacancy, I cannot I am not at all. But as of 23/7/2009, when I am even according to them, it's not my case, it is their case as well. That as of that, I was eligible for people. They definitely deliberately they did not give, but instead they give promotion in December actually.
Deliberately, Allah, they have given reasons for that one. They have given. They have.
Who has been able to secure eligibility as on that day, and he is considered for promotion. If no decision had taken place on 23/7/2009, or that they would not have fought for normal absence on 21/8/2009, much before passing into the second order of promotion. Our struggle will not from us always with going vain.
ಅಲ್ಲ ಅಷ್ಟೆಲ್ಲ ಮಾಡಿ ನೀವು ಕೈ ಕಟ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರಲ್ಲ 8 ವರ್ಷ, ನಾವೇನ್ ಹೇಳ್ಬೇಕು ನಿಮ್ಗೆ?
Further, the entry models cannot have those mergers in the final order. It carries some significance. You also carries this one has taken note of the submission of my submission as well as the responsibility made for 28. Second paragraph number 48.
If you see this interim order dated 14/12/2009, internal page number 5 of the previous order. ಅದನ್ನು ಓದಿದ್ರೆ it is clear that you are at serial number 26. But what was available for GM was only 11. ಮತ್ತೆ ಹೆಂಗ್ ಬರುತ್ತೆ ನಿಮ್ದು? 99 eligible AAOs were considered for filling up 25 clear vacancies as on 30/11/2009, out of which the DPC has cleared 22 posts, from amongst which 11 belong to general merit. 11 belong to general merit. You are at serial number 26. ಮತ್ತೆ ಏನ್ ಮಾಡೋದು sir? If you have not got a clear order at the hands of this court, you are not able to convince this court at that point of time, ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? Then if you are aggrieved with this order, then you should have challenged it. You took this order. No sir. And I don't think ಅದೇನು ಭಾರಿ ದೊಡ್ಡ ಇದಾಗ್ಬಿಡುತ್ತೆ. I don't think what you are saying is correct.
They are talking about November 2009.
ಬರ್ಕೊಳ್ಳಿ.
Whereas I am talking about July 2009.
Yes sir. ಇಲ್ಲ ಬರೋದಿಲ್ಲ. The petitioner who has since retired as accounts officer of the respondent KPTCL, filed this petition on 14th of July 2020, while still in service, with a prayer to quash the endorsement dated 7/3/2020 at Annexure L, and seeks direction to the respondents to grant retrospective promotion with effect from 21/8/2009 with all consequential service and monetary benefits, including payment of arrears along with interest. Stop. Next para. It is not disputed that earlier the petitioner, along with two other persons, was before this court in writ petition number 25871-873 of 2009, seeking a direction to the respondent corporation to consider the case of the petitioners for promotion to the post of accounts officer in pursuance and as a consequence of the decision taken in the Departmental Promotion Committee proceedings dated 23/7/2009 and the petitioners exercising the option as per the communication dated 21/8/2009 and for issuance of orders of promotion. Stop. During the course of those proceedings, several interim directions were given by this court. Stop. 3 posts were initially directed to be kept reserved for the petitioners therein. Stop. However, by a subsequent interim order dated 14/12/2009, this court felt that it would be unfair if 3 vacancies are kept open without allowing the promotions to be given effect to. In the very same order, Next para. Last sentence. Learned counsel for the petitioner submits that when it is clear from the material available on record, including the contents of the impugned endorsement, at annexure L, that a departmental promotion committee proceedings was scheduled to be held on 25/8/2009. Full stop. However, due to the by-election and the code of conduct issued by the election commission, the departmental proceedings, departmental promotion committee proceedings could not be held. Full stop. However, immediately thereafter, in the next departmental promotion committee proceedings dated 31/12/2009, taking note of the backlog vacancies and in terms of the government order dated 24/6/1997, decision was taken to consider 99 eligible assistant account officers for filling up 25 clear vacancies as on 30/11/2009. So, the learned counsel for the petitioner would submit that if a decision was taken in the departmental promotion committee proceedings, which was required to be held on 23/7/2009, or immediately after the code of conduct came to an end, comma, several of the other persons who were under the reserved category, comma, who were not eligible to be considered for the post of accounts officer at that point of time, comma, would not have got an opportunity to seek promotion to the cadre of accounts officer. Full stop. Nevertheless, comma, the learned counsel for the petitioner submits that since promotion is admittedly given to other persons on another data 2010 9/4/2010. Huh? Ah. Ah.
Before 31/7/2009, when the SS became eligible, or others also during, because they themselves say, in their reply, before the backward, that juniors are being considered.
All right.
Nevertheless, learned counsel for the petitioner submit that since promotion is admittedly given to other persons on
Ayana date 2010 9/4/2010, comma, the case of the petitioner for promotion from the said date at least should be considered. Stop. The learned counsel, comma, nevertheless points out from the interim orders passed by this court and the final order passed by this court in WP number 25871-873 of 2009, dated 27th of June 2012, that the proceedings of the DPC was in fact held on 23/7/2009, comma, when the petitioner was eligible for promotion. Thereafter, with a communication dated 21/8/2009, the petitioner, comma, along with the other persons, was asked to exercise their option online, and the petitioner had indeed exercised that option. Full stop. This submission is made since it was pointed out by the learned counsel for the respondent corporation that promotion was granted only from 4/10/2010 and nothing happened 9/4/2010 and nothing happened prior to that, comma, even if a decision, even if the proceedings of the DPC had been taken place on 23/7/2009. Full stop. The learned counsel for the petitioner submits that the petitioner has since attained the age of superannuation during the month of February 2022, and if this benefit of retrospective promotion is granted, comma, if not for the sake of arrears of salary, comma, at least for sake of fitment, comma, the petitioner would be benefited. Full stop. Next para. For contra, learned counsel for the respondent corporation draws the attention of this court to the interim order dated 14/12/2009 passed by this court in WP number 2 and stop. The learned counsel submits that the developments that happened consequent to the DPC proceedings dated 23/7/2009 and the subsequent DPC proceedings consequent to the by-elections and the code of conduct issued by the Election Commission has been noticed by this court. Stop. Material was placed before this court, and this court took note of the fact that 99 eligible assistant accounts officers were considered for filling up of 25 clear vacancies as on 30/11/2009, out of which the DPC cleared 22 posts, from amongst which 11 belong to general merit, 9 to scheduled caste and 2 to scheduled tribe category, while 3 posts have not been filled up in terms of the interim directions given by this court. Stop. Most importantly, it is pointed out that at that point of time, it was noticed that the petitioners were found at serial numbers 26, 29, and 31 in the seniority list, and therefore they do not fall within the zone of consideration for promotion. Stop. The learned counsel for the respondent corporation would therefore submit that when the petitioner did not fall within the zone of consideration for promotion, there was no occasion for the DPC to consider the case of the petitioner for promotion. Full stop. Nevertheless, immediately after the petitioner became eligible for promotion, the petitioner has been promoted as on 1/2/2011. Stop. Next para. Learned counsel for the respondent corporation would also place reliance on a decision of the Honorable Supreme Court in the case of Union of India and others versus KK Vadera and others, AR 1990 SC 442, wherein at paragraph number 5, it was held that it was held as follows. Extract page number 3, statement of objections. Next para. Heard the learned counsel for the petitioner, comma, learned counsel for the respondent corporations, and perused the petition papers. Full stop. Next para. What falls out of the submissions of the learned counsels and from the material available on record is that the petitioner has waited for too long and has not shown his anxiety in getting the orders of this court executed. Full stop. Petition number 25871-873 of 2009, comma, which was filed by the petitioner along with two other persons, was disposed of on 27th of June 2012, comma, with a direction to the respondent management to consider the claim of the petitioners for retrospective promotion with effect from 21/8/2009. Comma, as expeditiously as possible and at any rate within a period of 6 weeks from the date of receipt of a copy of the order. Stop. The petitioner has slept over the rights that he was granted by this court consequent to the directions issued in the earlier round of litigation. Stop. It is by now well settled that law does not come to the rescue of a person who leaps over his rights. Stop. Next para. Even on merits, comma, what this court finds is that when the case of the petitioner was considered along with the other eligible candidates for promotion as per the DPC, it was held subsequently, comma, he was not within the zone of consideration. Full stop. This is because the respondent corporation was required to consider the filling up of the backlog posts in terms of the government order dated 24/6/1997. And adopted by the respondent corporation. Stop. No doubt, the petitioner has contended that if the DPC had taken place on 23/7/2009, and in fact had taken place on 23/7/2009, when the petitioner was admittedly eligible for promotion, and subsequently, as called upon, the petitioner had exercised his option online, on 21/8/2009, the petitioner would have been benefited. Stop. Nevertheless, what is evident is that the petitioner has accepted the said position and did not challenge the subsequent DPC proceedings. And therefore, it is now too late in the day for the petitioner to contend that as per the DPC held on 23/7/2009, the petitioner should have been promoted. So, the petitioner accepted the decision of this court as per the order dated 27/6/2012, and in fact never pursued the directions given by this court to the respondent corporation. So, next para. This court is also not in a position to accept the contention of the learned counsel for the petitioner that if not for the arrears of salary, the case of the petitioner could be considered for retrospective promotion only for the purpose of fitment and retirement benefits of the petitioner, since the learned counsel for the respondent corporation is right in her submission that if such an order is passed, it would open a Pandora's box. Stop. Next para. For the reasons stated above, this court is of the considered opinion that the prayer made in this writ petition cannot be allowed. Stop. Accordingly, the writ petition stands dismissed. A week's time is granted the petitioner for complaints of office objections.
Appear for the petitioner, my lord. this case, I for the petitioner, I filed a
Yes.
memo for withdrawal with liberty to file a fresh petition. In the petition, in this petition, my lord, I have challenged the refusal of the first respondent DC to consider the stay application filed in the revision before him, challenging the order of Annexure H passed by the second respondent AC under section 4 of the SC/ST OBC Reservation Act. Now it's come to light, my lord, it pertains to sixth respondent. The sixth respondent has been appointed prior to the filing of the writ petition. Hence, neither is to challenge the appointment of the sixth respondent. Hence, I seek liberty to withdraw this petition with liberty to file a fresh petition, my lord.
You had to challenge it before.
Revision was filed before the first respondent DC. He refused to consider the stay application, and that is under challenge before this honorable court in this writ petition. In the meanwhile, it has come to light that the sixth respondent has been appointed prior to the filing of the writ petition itself, my lord. We've got documents to that effect. Hence, I seek permission to withdraw with liberty to challenge the appointment.
The petitioner has filed a memo dated 21/2/2022 seeking leave of this court to withdraw the writ petition, with liberty to challenge the appointment of the sixth respondent, which was ordered subsequently. Stop. The memo was taken on record subject to all these exceptions. The writ petition stands dismissed as withdrawn, reserving liberty to the petitioners, as prayed for.
Much of it.
I am for the petitioner in this case, my lordship.
Yes.
The petitioner has filed an application for production of additional document, my lordship.
2015 additional documents.
Yes, my lordship. As per the order dated by the 27/9/2021, my lordship, by of this honorable court, the government is directed to.
Any objection? Copy
I will serve it, my lordship. Today itself, I will serve it, my lordship.
Counsel for the petitioner is directed to serve a copy of IA number 1 of 2022, along with the annexures.
Please, my lordship.
On the learned AGA and the learned counsel for respondent number 5.
I have served the government, my lordship, already.
Please release this matter on 10th of March.
Please, my lordship.
Appealing for the respondent university, my lords.
Then a counsel for the petitioner has filed a memo. Date memo dated 25/2/2022, seeking leave of this court to withdraw the writ petition as not pressed. The memo is taken on record subject to all just exceptions. Full stop. The writ petition is accordingly dismissed as not pressed. So date was 25/2. Connected matter ಎರಡುನಾ same order. Early hearing. Early hearing. Early hearing application ಹಾಕಿದ್ದೀರಾ? ಅಲ್ಲಲ್ಲ, ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದೀರಾ?
ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲ, ವೇಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್. ಹಿಯರಿಂಗ್ ನಿಮ್ಮದು
ಎರಡೂ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಇದೆಯಲ್ರಿ?
ಒಂದು ಪೋಸ್ಟಿಂಗ್ ಅಂತ ಬಂದದ್ದಕ್ಕೆಲ್ಲ ಅರ್ಲಿ ಹಿಯರಿಂಗ್ ಅಂತ ಆಫೀಸ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಕ್ಕೆಲ್ಲ ಅರ್ಲಿ ಹಿಯರಿಂಗ್.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್? ವಾಟ್ ಇಸ್ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ವೆಕೇಟಿಂಗ್?
And the vacating application is ordered to be considered along with the main matter. ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ ಪೋಸ್ಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅವರು ಹಾಕಿರೋದು.
ಸರಿ, ವಾಟ್ ಇಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ?
But we are ready to pay and settle the entire matter. They refuse to take it. And therefore, without following any of the procedure.
ಇವಾಗ ಎಷ್ಟು ಆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ? ಎಷ್ಟು ಆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ?
Auction amount was about 60,000.
60,000.
Auction, you my lord, is 22 lakhs.
22 lakhs.
Less than 22 lakhs.
ಆಯ್ತು. Now they have auctioned the property for what rate?
60 lakhs.
60 lakhs. 60 lakhs.
Yes. But property value according to them only is more than 80. According to us, more than the judgment, it was more than a crore. It is produced to say, before saying, even after saying, we want to pay the entire due. We tendered the check also, they did not accept it. Same was confirmed. Therefore, immediately we came before this court and signed the petition. This court may not to set not to show you one of the two deposit the amount which was missing. More than the sale amount. We deposit.
Yes, sir.
What is what my lord? It is there in the order. But totally we have deposited 25 lakhs 61,400 rupees. And 25 lakhs totally before this court. As per their own self-proclamation, but as per their own self-proclamation, the due was 21 lakhs 92,942.
ಮತ್ತೇನ್ರಿ?
I appear for the auction purchase.
Auction purchase.
Now, my lords, the contention that my lords collusive sale, my lords, that is not correct. I became the successful bidder.
All right.
And that is one. Second submission is, my lords, the contention that, my lords, the property was sold for 60 lakhs. That is also not correct. Property was sold for 81 lakh 20,000.
81 lakhs.
Yes. Kindly turn to annexure R3. Bid amount is 81 lakh.
When was the auction conducted?
Auction was purchased, conducted in the year 2019.
2019 alle, within a period of 2 months or 3 months, they have paid more than what was shown in the auction sale notice.
They were directed to pay 25 lakh rupees by this honorable court, and thereafter they have deposited. Not earlier. ಅಲ್ಲ, ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಕೊಟ್ಟ ಮೇಲೆ.
Correct, sir. That was their contention, that even earlier we went before them, they did not accept the payment anta. Now to show the bona fides, they have paid the entire amount. More than entire amount.
And not only that, on admitted facts, there is clear cut violation. 30 days sale proclamation is mandated.
Yes.
Under the rules.
ಯಾರು ಇದು ಸೊಸೈಟಿಗೆ ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ?
30 days sale notice sale proclamation is mandatory under the rules. Not here admittedly. Sale proclamation, this paper publication was taken on 4/7. But sale was held on 22/7. That is not hardly about 18 days. 30 days were not under rule 38. and they should call upon them, my lord, to deposit, my lord, 38(2)(a). My lord, before issuing seal confirmation, they should issue a notice and call upon to pay the entire. That was also not done. And thirdly, sale should be held at the spot. At the spot or near the spot. But that is also not done. According to their own confirmation, sale was held at the head office of the cooperative. So also that was also. For property, which is according to the only value at more than 80 lakhs.
Even on a writing when you received notice,
yes.
Did you give it in writing that you are prepared to pay the entire amount?
They did not receive anything. We went with the application, we went with the check.
Yes.
Dispute, the award passed in the dispute is not challenged.
Huh?
The award.
That's all right. They are accepting.
Yes.
They are accepting. That's what we are saying. They are not saying that we are not liable. And to show their bona fides, they have paid the entire amount. 25 lakh 61,400 they have paid.
25 lakh is paid, deposited before this court.
If there is a direction, if there is a direction given by this court,
yes,
whether it is to be deposited before this court or to the bank,
yes, yes,
and they have complied with the direction.
Before this court, that was the direction.
Therefore, if the entire entire award amount has been deposited by the petitioner, who has a right to protect his immovable property, then
my lords, my interest will have to be protected. Lords, I being the successful bidder, my lords,
when the additional money regarding the right of the purchaser,
I have
in such a situation,
yes,
what can be done? Another, there are several judgments.
I have the
when
he takes that risk and participates.
And
not only that, now my lord, more than that amount you have deposited.
Yes.
22 lakhs, now 25 lakhs, and this court has directed my lord to invest that deposits in fixed deposits.
So that benefit also you get if he is entitled.
Yes.
He is entitled.
Yes.
Court, my lord, in 1993 itself, my lord said that in the event if auction is set aside, then I am entitled for my lord's interest and also solution.
Adikene, this court has said you invest it in a bank where it will earn interest.
Now the question is, my lords, if the sale is set aside, so who has to pay the solution and my lord's interest? Now the petitioner's contention is it is because of the fault on the part of the bank. Lords, the property is auctioned. The Supreme Court says, my lords, it is the person at whose instance sale is set aside. So he should pay. The question again, my lords, is how much is the solution? In some cases, Supreme Court says, my lords, it is 20%. Whereas, my lords, in some other cases, my lords, 5%. It is up to my lords to take a call, my lords, how much solution I am entitled.
Yes.
Admittedly, my lords, I have invested this money in the year 2019.
Citation. Please give that citation.
Yes.
You please go through that one and make us.
Lords, even then, my lords, now
Allah sorry, sir. In such situation, if there is a ruling of the Supreme Court, then we'll have to take note of that. He is entitled to point it out. So therefore, that is why I said you please go through that also. If you have something to submit on that one, you please submit it.
Lords, now the Supreme Court says, my lords, if we don't protect the interest of auction purchasers, then there will be no bidders only, my lords, in the auction. So that is what they say. If they are,
sir, our real taradu 81 laksha anbuto. Nee veliddu 80 laksha.
Allah,
paid 81 lakhs.
60 ಲಕ್ಷ ಅಂತ ನಾವು 81 20 ಕೊಟ್ಟಿದ್ದು 2019 ರಲ್ಲಿ 3 ವರ್ಷದಿಂದ ನನಗೆ ಪ್ರಾಪರ್ಟಿ ಇಲ್ಲ, ದುಡ್ಡು ಇಲ್ಲ, ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ. Now my money is with the bank, his money is with the court. I don't get any benefit out of it.
Matter is called out. There is no representation for the second respondent. Cooperative bank, cooperative society, cooperative bank. So the matter is required to be heard and disposed of finally. So therefore, release this matter on 9th of March 2022. So. If there is no representation for the second respondent bank on the next date of hearing, comma, this court will have no other option than to proceed with the matter. Or once everybody.
Please.
Yes.
I appear for the petition on the roads in item number 24. Roads on 9th November 2000.
Of filed applications stating the interim order.
My lords, may I make one submission, my lords? On 9th November 2020, the interim order was granted. Then on 19th July 2021, there is an order recorded by this honorable court.
Yes.
Application is filed by us. So
for vacating.
that I could make submission.
Alara, he was only pointing out to the earlier previous orders. You know,
Yeah, that's all I am saying. I am appearing for the petitioners. On 19th July 2021, there is an order passed by the honorable court with the consent of all the learned counsel that the matter would be heard. We were directed to complete the pleadings and pleadings have been completed. If my lords could take 19th July 2021. Both sides pressed our IAs. Then the honorable court after hearing said, serve on all parties, complete the pleadings. If service is not complete, you can press for interim orders. Service has been complete. I am ready to argue the matter on merits. If my lords could take up at 2:30, my lords, I will be there physically to assist the court.
It has to be listed for final hearing.
My lords, in the interlocutory stage, but only thing is at 2:30 and 3, both parties can complete within 1 hour each.
The interim order as prayed for is not granted. Your lordship, on 9/11/2020 passed an interim order status quo that promotion for this is what the respondent authorities are directed to maintain status quo with regard to the promotions of the petitioners and the respondents till the next date of hearing. Interim order is continued. What is meant by the giving the order? The note, the interim order as prayed for is stated. Where they have sought to
you can't read that one because if this court simply says no.
Taking advantage of that, they have secured promotion, but they want the respondents not to take promotion, or they want the KPTSL not to promote the respondent. That's why they are.
No, we have never said that. In fact, we have never said that. Let him not say what is not there on record. And on 19th July 2021, having agreed to argue the matter, why my learned friend is hesitant to argue the matter on merits?
Issue notice to other respondents. The respondent authorities are directed to maintain status quo with regard to the promotions of the petitioners and the respondents till the next date of hearing. What is the interim order prayed is, my lord, direct the respondents not to promote respondents to 75.
If this court simply says interim order as prayed for on there, then we'll have to read that note.
Therefore,
our note suppo. They should not have put up that note.
Finding out that, notwithstanding that, my lord, the promotion shall not be given to both the petitioners and the respondents. They have taken promotion and they want, but they file an IF of 221, 2 of 221, my lord, asking for stay not to promote the respondents. But kindly take, my lord, along with the IA.
My lord, that IA has not been granted. That is why the court said all the IAs have to be, all the matters have to be heard on merits.
But it is clear from the order dated 9/11/2020.
Yes,
that is continuing.
Are directed to maintain status quo with respect to promotions of both the petitioners as well as the respondents.
Yes, my lord. Yes,
the petitioners are being promoted, my lord.
No, respondents have been promoted.
No.
That is pursuant, my lords, I can file this one. That is why, after hearing all this, the court said that we will hear the matter on merits. What happened was subsequently there was an order in another petition in the division bench.
The employer.
The employer, at the employer's instance.
Madam, how did you grant this promotion?
We have made
in violation of the interim order passed by this court?
Lordship, my instruction is that it is only a in-charge arrangement.
In-charge arrangement, not a promotion.
Not promotion.
It is
that has been given to respondents also.
discharge arrangement, they are promoted because the matter is pending. This is a clever way of defeating your lordship's order.
Anyway, Learned
Clarify.
Counsel is saying he is ready to argue on the merits of the matter.
That is a different thing, my lords. Kindly clarify.
ಅಲ್ಲ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಗೂ ಮಾಡಿದಾರಂತೆ petitioners ಗೂ ಮಾಡಿದಾರಂತೆ ಏನ್ ಮಾಡೋದು
ಮಾಡಿದ್ದಾರೆ
ಎಲ್ಲರಿಗೂ ಮಾಡಿಲ್ಲ. There are about 75 respondents. All are not full. Whenever
ಎಷ್ಟು ವೇಕೆನ್ಸಿ ಇದೆಯೋ ಅಷ್ಟು ಮಾಡ್ತಾರೆ.
Wants to promote the respondents, they will say there is the interim order of status quo is there.
No, but let them show one endorsement issued like that, Maros.
That to be clarified.
Now an application is filed
Vacate the interim order of status quo. It doesn't serve any purpose. Now the management is ready to grant promotion to both the petitioners as well as the respondents. Then why to maintain status quo?
My lord, sir, may I submit, my lords. Their game plan is to have the state dissolved and keep the petition pending for next 10 years. Now interim order is not affecting anybody. Therefore, my lords, on 19th July 2021, after hearing all this, it was agreed that the matter would be heard on merits. And date was fixed with the consent of all the senior counsels. Thereafter, the matter has not reached or some are there, it is going on. All that I want is an early disposal of the petition.
All of them are eligible. Then what is the difficulty? If all of you are eligible for promotion and it will be considered, what is the difficulty?
My lord, the point is this, my lord. All of them are being promoted irrespective of independent of this interim order. All of them are on independent charge basis only, in charge basis only. No, my lords, all that I want is that interim order is not affecting anybody. If it is dissolved, the difficulty is this matter will remain pending forever.
Not that.
Therefore, what I am submitting is this, my lord. Nobody's promotion, my lords. Nobody's.
All of you are eligible for promotion and they are ready to give promotion to everyone. What is the difficulty?
Then, my lord, they cannot give regular promotion to anybody because there is another case pending before the Supreme Court.
Then what is it?
I'll explain all these things, my lord, placing on record. What are the order passed by the division bench? What is the order passed by the Supreme Court? Not in this case. In this case, the matter has not gone to higher forums. But regarding the determination of the seniority itself, there is a pending dispute, which where my lord, the learned judge of the Honorable Court granted an interim order that while making a final seniority list, you have to implement R.K. Subrawal. That was taken by the management to the division bench. In the division bench, order was modified saying that affirming that part of the order which said that you have to implement R.K. Subrawal, permitting the management to make in-charge arrangements with full statutory powers. That was taken to the Supreme Court by the management. Supreme Court has permitted them to publish a final seniority list. But insofar as the promotions are concerned, it has said that you have to implement R.K. Subrawal. Therefore, the problem does not arise because of this interim order. Problem to grant promotion arises from that interim order granted by the division bench and by the learned single judge in Gurumurthy's case. In this, my lords, the issue involved is a sharp question whether the KPTCL can say that I will correct the seniority from 2010 direct recruits onwards, but not correct it earlier to that date, which is contrary to the judgment suffered by the KPTCL at the hands of this Honorable Court. My lords may have this today or Monday or Tuesday, any day. I will come and address the arguments at 2:30.
That is the issue, and the same is pending before the Honorable Supreme Court.
No, this issue is not pending. This issue regarding the interstate transfer of direct recruits and those appointed by transfer, that is those who diploma engineers and graduate engineers, that is not subject matter of any dispute. It is concluded by the Supreme Court in P. Sudhakar Rao's case. All that I am seeking, the single point prayer in this writ petition is to implement the board resolution
passed pursuant to K. Narayan's case. Therefore, my lords, if my lords grant me 15 minutes on minutes, I will establish what is the matter.
You will fix up
If my lords have time at 2:30, I will come at 2:30. Otherwise, my lords may fix a date.
Are you ready to argue the matter today?
No, I am not ready. Please kindly clarify this interim
No,
order.
no, no. I will give a date next week. We will hear and dispose it up finally.
Already there is an order by your lordship. As far as this ABT appointees are concerned.
Sir, whatever it is, I will give a time and date. You please come and argue the matter. We will dispose of it. List this matter for final disposal on 9th of March 2022. Next week. Huh? Aye, 2:30. At 2:30. On
Lord, interim order to extend till that day.
Lord, I couldn't hear the date. Lord, 16th, my lord.
He wants to maintain. He wants to maintain the petition. He wants to maintain the confusion also. Last time extend
ಮಾಡಿದಾರಲ್ಲ.
Confusion is created by Mr. Devadasan.
Earlier stands extended to the next day. Yes.
But may I only
I am for the petitioner in this case.
the matter is not heard finally. In any case, kindly clarify the intent.
ಅಲ್ಲ ಅವ್ರು ಇವತ್ತು ರೆಡಿ ಇದ್ದಾರೆ.
ಅವ್ರು ರೆಡಿ ಇರ್ತಾರೆ, ಅವ್ರು ಯಾವ ಬೇಕಾದ್ರೂ ರೆಡಿ ಇರ್ತಾರೆ. He should have told me that he is ready to argue the main matter. The matter is listed.
Yes.
Yes. When it is matter is listed.
516, my lord. My lord, the petitioner in the prayer number 1 sought for direction to the respondent number 5. The retirement benefits, debt and the gratuity, leave encashment, pensionary, etc. in favor of the petitioner. Well, same relief sought by the petitioner in a review petition number 10/2020 before the secretary.
You are for whom?
Respondent of 516 institution.
I am for the petitioner. I am for the petitioner in this case, my lordship.
Same relief sought in the review petition number 10/2020.
No, my lordship. My friend is making a false submission.
Department of Higher Education, MS Building, Milan. Same prayer.
My friend is making false submission, my lordship. That is what, my lordship.
Disposed of on
I have filed an
19th November
application.
2021.
ಸ್ವಲ್ಪ ಇರ್ರಿ ಸರ್. IA 1 to 3 of 2022 has been filed. For what?
Yes, my lord. No, my lordship. Petition is there. I have filed an application producing the order passed by the first respondent, my lordship, in revision petition.
1 to 3 of 2022.
That I have filed an application for production of document, my lordship. That is the IA 1. The second one is for memo IA for posting of the writ petition, my lordship.
For posting ಆಗ್ಬಿಡಿ. ಆಯ್ತು.
Another
IA
is
3 for direction.
Direction. I have produced the document, my lordship. One more. Production of document, my lordship, I have produced.
ಆಯ್ತು. ಒಂದ್ ನಿಮಿಷ. ಹೇಳಿ ಇವಾಗ ಹೇಳಿ ನೀವು.
I am not served with any.
ಆಯ್ತು ಅದ್ ಬಿಡಿ ನೀವ್ ಹೇಳಿ. Your
my submission, my lord. The prayer number 1 in the writ petition, same prayer sought by the petitioner before the principal secretary, Department of Higher Education, MS Building, in the review petition number 10/2020. Same relief. The department has passed the order on 19th November 2021. Allowed their petition.
Allowed the petition.
They allowed their petition. And well, there is serious allegation.
What is the prayer?
Prayer by the petitioner for release of pensionary benefit and gratuity, etc. before the authority.
He was working as what?
He was working as FDA in a Arts and Commerce College of Vivipuram College. There is a serious allegation of misappropriation money of 21 lakh.
There is a direction. There is a direction of the concerned minister.
Not concerned minister.
ಏನ್ ಹೇಳಿದ್ರಲ್ಲ ನೀವು?
Additional secretary.
ಅಂದ್ರೆ ಗವರ್ಮೆಂಟ್.
Government has granted stay. Additional secretary has granted stay of the inquiry proceedings initiated against the petitioner. Therefore, they were not allowed the institution to complete the inquiry proceedings. Whenever we issued a fresh show cause notice in accordance with law, he approached the secretary and got stay because of their influence on the secretary.
So what is the prayer here?
My lordship, in this writ petition, my lordship, what are the argument canvassed
Director
by my friend is totally
suitable action,
misconceived, my
sanction,
lordship.
release and pay the retirement benefits. Immediately enquiry pending idu
My
adanna
lordship,
stay
my lordship.
ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ ಅಂತಲ್ಲ
No, my lordship. No, my lordship. My friend is arguing. My friend is making a false submission, my lordship, before this honorable court. The petition filed before the revisional authority is totally different, wherein that was the third inquiry initiated against me, my lordship, by the respondent. In the first inquiry, my lordship, the penalty order has been passed by the respondent.
Correct, but it is only an order of stay.
No, my lordship. No, my lordship. That is not stayed. That is the third inquiry was stayed. The third inquiry was stayed, my lordship. On the same set of charges, they have issued 3 charge sheets, my lordship. On the same set of charges, my lordship. First inquiry, my lordship. First inquiry, my lordship, the penalty order was passed, my lordship. Thereafter, the penalty order has been set aside, as that is not made in the, as per the rules, my lordship, that the charges also not proved, my lordship. Thereafter, they have issued one more show cause notice, my lordship, on the same set of charges under the provisions of Vakaligra Sangha enactment, my lordship. That is also, my lordship, during the pendency of the inquiry, my lordship, they have not granted any benefits. I have retired in the year 2015, my lordship. 30th June 2015, I have retired. The second, during the subsistence of second inquiry, my lordship, they have issued one more show cause notice by serving the charge sheet, my lordship, the third inquiry, my lordship. The third inquiry was stayed by the revisional authority, my lordship. On the same set, this is the method adopted by the management as to how they are protecting to pay the pensionary benefit which the petitioner is legally entitled.
So what direction are you seeking now?
No, my lordship, as per the order passed by the revisional authority by annexure or, my lordship, I have produced the document in annexure, my lordship. I draw your kind attention, my lordship, page 6 of.
Please to direct the fifth respondent to take further action so as to release the pay and retirement benefits payable to the petitioner pursuant to the direction issued by the first respondent in revision petition number so and so, annexure R.
Yes, my lord. I have produced the document along with a separate annexure application, my lordship. That revisional authority by order dated 19 November 2021, my lordship, has passed an order, a detailed order, my lordship. In the respondent has also contested before the revisional authority. The page 14 of the relevant portion of the order, my lordship.
Additional document,
additional document on
the petition.
Please serve copies of all this.
ಅಲ್ಲ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಅದನ್ನ ಬಿಟ್ಟು ಬೇರೆ ಏನೇನೋ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಯಾರು.
ಮಾಡಿ. You please serve.
Please, I will serve it.
Learned counsel for the petitioner is directed to serve copies of IAS number 1, 2 and 3 of 2022 on the learned counsel for
5 and 6.
Response number 5 and 6 and the learned AGA. Release this matter on 10th of March.
Please, my lordship.
Yes.
Appear for the respondent number 4 and 5. Matter request to be heard, madam.
Dispensation, vacating.
No, vacating ನಾನು ಹಾಕಿದ್ದೆ. Matter requires a final hearing because it was.
After hearing only minutes, this interim order was possible. After reading both sides minutes, interim order was possible.
ಅದನ್ನ ಹೇಳ್ತಾರದು ಅವರು. Not pressing on the IA for vacating, it has to be heard and disposed of finally ಅಂತ ಹೇಳ್ತಾರೆ. ಏನ್ ಮ್ಯಾಟರ್?
Next week ತಗೊಂಬಿಡಿ ಸರ್, next week.
2021 matter, sir. There are very old matters waiting.
Interim order was granted minutes. Even then minutes, the petitioner has not been allowed to continue in the service minute.
Has not been allowed.
He has filed a contempt. I have filed a vacating application, and this honorable court just. No.
ಸರಿ ಆಯ್ತು, ಅದನ್ನ ಅಲ್ಲಿ ಹೇಳಿ. ಈಗಾಗಲೇ ಕಂಟೆಂಪ್ಟ್
not to precipitate ಅಂತ ಹೇಳಿದ್ರು.
Not to precipitate ಅಂತ ಇಲ್ಲಿ ಅವರೇ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. There is an order
to precipitate this matter.
ಅಂತ ಹೇಳಿದ್ರು.
No, in the contempt they should not precipitate ಅಂತ ಇಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ. Because I have pressed for the interim order, vacating the interim order. It may be heard, my lord, next week any day.
Saturday.
What is the matter about?
This is regarding appointment, my lord. The petitioner was appointed as the assistant engineer minutes on the basis of Marskars minutes of Karnataka State Open University minutes. he was admitted into the third year course minutes of completion of diploma course minutes. At that time, there was a recognition.
Technical education, distance education, Supreme Court holds. They are not valid degrees. In fact, the university also filed objections.
KSOU degrees regarding that.
Might not be this matter, but other KSOU degrees.
But I know, but
nothing has come out of the
yes.
This is one similar matter. The degree was
KSOU. But that order, government order does not come to the rescue of the petitioner?
No.
It will come to my rescue.
Question, my lords, of the engineering courses, and further no courses have been entertained by the
the engineering course.
Engineering, technical course.
Technical courses, kashta.
2018-19 Supreme Court judge.
In fact, my lords, I appear for KSOU.
The applicant was appointed and reported for the duty.
Our case is
2016.
16 minutes. He completed his course minutes 2014, August 2014.
That was before the UGC took over.
Please minutes.
No. Supreme Court.
After the UGC. When did the UGC take over? 2012.
Before that, he got admission.
May make one submission.
But right from the day when they took over, they have been giving advertisements, and they have sent notices to all of you, all the universities.
Please, not to this university minutes. They have not sent any university minutes.
May make a mention, lords, in this matter. Lords, I appear for KSOU. Lords, they are not direct students of lords, the KSOU. They are lords admitted by the study centers. We were in agreement with those study centers, lords, that they will lords, take the necessary permission and affiliation from ACT and other agencies. Nothing of that sort has been done, lords, by those lords, authorities who have admitted them, study centers. As such, our case is that, lords, it's not a valid degree. Though, lords, the certificates have been issued, the degree acquired by them is not valid. Lord, is our lords stand.
ಇವಾಗ ನೀವೇ ಅವರ ಅಗೇನ್ಸ್ಟ್ ಆಗಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ನಾನು ವಿರುದ್ಧವಾಗಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ನನ್ನ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ತೊಂದರೆ ಇಲ್ಲ, ಕ್ವಾಲಿಫಿಕೇಶನ್ ಅಲ್ಲ ಅಷ್ಟೇ.
ಇಲ್ಲ, ಯೂನಿವರ್ಸಿಟಿ ಮಾಡಿದ ತಪ್ಪಿಗೆ ಪಾಪ ಪಿಟಿಷನರ್ ಇಸ್ ಸಫರಿಂಗ್ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ.
ಯೂನಿವರ್ಸಿಟಿ ಮಾಡಿದ ತಪ್ಪಲ್ಲ.
ಹೌದು, ಯೂನಿವರ್ಸಿಟಿ ಹ್ಯಾಸ್ ಕಮಿಟೆಡ್ ಎ ಬ್ಲಂಡರ್ ಹಿಯರ್.
ಯೂನಿವರ್ಸಿಟಿ ತಪ್ಪಲ್ಲ.
ಮೈಸೂರು ಯೂನಿವರ್ಸಿಟಿ
ಅಗ್ರಿಮೆಂಟ್ ಇಸ್ ಕ್ಲಿಯರ್.
Learned senior counsel is arguing for you. ನೀವ್ ಯಾರ್ಗ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ನಾನು ಈ ಬೋರ್ಡ್ಗೆ ಅಪಾಯಿಂಟೆಡ್ ಹಿಮ್ ಆನ್ ದ ಬೇಸ್ ಆಫ್ ದಿಸ್ ಎಜುಕೇಶನ್ ಕ್ವಾಲಿಫಿಕೇಶನ್. ಕರ್ನಾಟಕ ಅರ್ಬನ್ ವಾಟರ್ ಸಪ್ಲೈ ಡ್ರೈನೇಜ್ ಬೋರ್ಡ್.
ಎಂಪ್ಲಾಯರ್.
ಅನ್ಫಾರ್ಚುನೇಟ್ ಪಿಟಿಷನರ್ ವಾಸ್
ಸ್ಟಡಿ ಸೆಂಟರ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅವರು.
ಇರ್ಲಿ, ಪರವಾಗಿಲ್ಲ. ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಸ್ವಾಮಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅದು ಏನಿದೆ ಶಾರ್ಟ್ ಕ್ವಶನ್ ಕವರ್ಡ್ ಬೈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಲ್ಸೋ.
Saturday.
ಆಗಲೇ ಸುಮಾರು ಮ್ಯಾಟರ್ಗಳು ಹಾಕೊಂಡ್ತೀನಿ.
ಯಾವುದು ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್?
If you want to take a chance, I will list it on Saturday.
ಇಲ್ಲ, ಸಾಟರ್ಡೆ ಬೇಡ ಸರ್.
Is this matter for final disposal on March?
Please,
2:30.
For final disposal ಅಂತ ಏನು ಬೇಡ. List this matter on 10th of March.
Please.
Please. Interim order granted earlier stands extended till the next date.
Please.
Court officer? Court officer?
ಮುಖ್ಯಮಂತ್ರಿ ಆಗ್ಬೇಕು. Prior to
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 27 ಏನಾದ್ರು ಮೆನ್ಷನ್ ಮಾಡಿದ್ರಾ?
ಹೌದು, ಅಟೆಂಡ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಸರಿ ಸರಿ.
ಬಿಟೆಕ್ ಇನ್ವಾಲಿಡೇಟ್ ಮಾಡಿ.
Hello, court officer. Court officer. Hello, court officer. Hello, court officer. Court officer.
ಏನ್ ಸರ್, ಏನ್ ಹೇಳಿ ಸರ್?
Serial number 24 ಯಾವ ಡೇಟ್ ಹೋಗಿತ್ತು ನೋಡಿ ಸರ್? ಇಪ್ಪತ್ನಾಲ್ಕು
9/3.
ಥ್ಯಾಂಕ್ಸ್ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 27 ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾವ್ದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ಕೊಡೋಲ್ಲ ಮೇಡಮ್. ಬೋತ್ ಕೌನ್ಸಿಲ್ಸ್ ಟು ಬಿ ಪ್ರೆಸೆಂಟ್. 27 ನೆಕ್ಸ್ಟ್ ತಗೊಂತೇವೆ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಈಗ ಎಷ್ಟು ಇದೆ? 27 ಕೊಡ್ತಾರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
ನಾಳೆ
ಅದೇ
No. Hello. No, I'm not interested.
You did not appear before the registrar? Huh? The AGA takes notice for response number 1. Issue notice to response number 2 and 3. Senate counsel for the petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA. Next para. Senate counsel for the petitioner submits that petitioner does not dispute the fact that he has availed loan from the third respondent, Cooperative Bank. So, the Assistant Register of Cooperative Societies has passed an award for a sum of rupees 27 lakhs 2,114 against the petitioner, as per Annexure A. Stop. So the same residential building where he is staying. Huh? Huh?
Scheduled property. Heading number 8 or 138, 1, 2, 3, 4, 5, 6, 7, and 8.
Then it is not a housing loan that you have availed. What loan is this? Huh? For construction purpose. You are prepared to pay the entire amount? Alla ivagalla. That is your submission. That if sufficient time is granted, you will pay the entire amount. Huh? The learned counsel would submit that on account of the loan was availed for putting up the construction of 8 apartments in the scheduled property. Although the construction has been completed, however, on account of the COVID-19 pandemic, the petitioner was not able to mobilize the funds to repay the loan. Stop. Nevertheless, learned counsel for the petitioner submits that if sufficient time is granted, the petitioner is ready to pay the entire amount awarded by the Assistant Registrar of Cooperative Societies. Stop. Next para. There shall be an ad interim order of stay of all further proceedings pursuant to the auction notice dated 25/1/2022. As per the newspaper publication at annexure C, till the next date of hearing, subject to the petitioner depositing 25% of the award amount with the third respondent Cooperative Bank within a period of 4 weeks from today, failing which the benefit given to the petitioner in this order will stand cancelled automatically. So, yes.
Asama Bhagat, number 4. Yes.
Yes. Ah.
He has been shifted to Chikarika depot, 821 on 28/21. Ready or not prepared what to hand over the charge. Lecture TV what charge. In the meanwhile, what the food inspector gave a complaint that been alleging what. But certain food articles are less than the border. Therefore, we need to get the relationship to make that. Not this is the complaint, eventually is an FIR registered by the police. Under I have prepared expedition. Due to the 486 of 20. All proceedings, including FIR, today. On the ground of draft, register criminal case, next arrest order, and before your last, which is suspension order, but there is no CPA to keep an official suspension only on a for the register criminal case. Only when charge sheet not they can keep them. Number one. Number two, I am not in the mistake area at all. Back in December 21, I'm cheated on that basis. Right.
Let us see, sir.
That's what I will do.
Let them come. Let them come. Let's see.
Let me see the order.
Is there any learned counsel who is on the panel of this corporation? Karnataka Food and Civil Supplies Corporation Limited. Nandish Gowda. Learned counsel Shri Nandish Gowda is directed to take notice for the respondent corporation. Learned counsel for the petitioner is directed to serve 2 sets of copies of the writ petition along with annexures on the learned counsel for the respondent. Release this matter on 8th of March, next Tuesday. For consideration of the interim prayer.
Number 12. Usually after they were taken and contracted basis, they were given certain salary, it was very low. Then when the government realized that at least minimum wages should be paid, they were brought on minimum wages basis. Thereafter, there was extension of any other basis. Subsequently, in 2019, what the government did, with respect to the contractual employees, they extended the benefit of 5th and 6th pay commission. That means not the entire salary, basic minimum area after that, I will continue. And when we came up before this order was out and earlier occasion, you were also pleased to pass an interim order not to dispense with the service of these contract employees. So next TC the page number 178 and I'm not. Here you will know that you will call it involvement. Hindi Naro, page number annex T3. Send back for you, will you? That recruitment model 2019 notification issue.
Those matters are still pending, is it?
Still pending.
Even otherwise, that order was passed during March 2019.
And on the
who has taken notice there?
Notice order.
Why there are so many other respondents?
I think I want to find a memo without giving up time. against respondent number 4 to 131. You are a memo. 1 to 3 notice was that. And right now I filed it.
Learned Counsel, Shri V.S. Naik, appearing for the petitioners, to draw the attention of this court to an interim order dated 18th of March 2019 in WP number 7496-7610 of 2019, and submits that those writ petitions were filed by 115 persons, and the petitioners are similarly situated persons working with the third respondent, Karnataka Veterinary, Animal and Fisheries Sciences University. And the Learned Counsel prays for similar orders. Full stop. The Learned Counsel would further submit that he is filing a memo seeking deletion of respondents number 4 to 131, who are private respondents, and no relief is sought against them. Full stop. In fact, the petitioners are praying for similar relief that has been granted to such those persons. Full stop. The memo is taken on record subject to all just exceptions. The petitioner, Learned Counsel for petitioner, is permitted to allow the response number 4 to 131 are permitted to be deleted from the array of respondents. Full stop. Learned Counsel for the petitioner shall carry out the amendment in the cause title forthwith. Full stop. Next paragraph. Learned AGA is directed to take notice for respondent number 1. Issue notice to response number 2 and 3. Stop. Learned Counsel for the petitioner is directed to serve a copy of the petition along with annexures on the Learned AGA. Stop. Mikiddo similar orders. Page number 179. Yes.
I'm appearing on behalf, my lord, I'm appearing for the petitioner on behalf of Senior Counsel Subbarao. Senior is feeling extremely unwell today and is unable to appear. May I request that the matter be taken up on Monday, my lord?
Lord, may I appear for the respondents? My lord, this is Nanage. I have been served with a copy, my lord. I have it only on 28th, my lord. I have sent the objections for the party approval, my lord. Your lordship may grant me a week's time to file objections, my lord. In fact, my lord, if your lordship says on 13/8/2021, my lord, there is already an interim order, my lord. Whatever now they are sought for. Now, my lord, the entire thing was sought on 13/8/2021 itself, and this honorable court, my lord, has only stayed recovery. Implementation of the refixation has not been stayed. Now, my lord, that is sought to be implemented now. Therefore, this honorable court has already stated that matter requires consideration. Therefore, my lord, let me file objections, my lord, on the main also. Your lordship may fix a date, my lord, matter can be heard and disposed of on merits only. 13/8/2021, if your lordship sees, what is stayed is only recovery. Now, my lord, I am not effecting recovery at all. Therefore, eitherly, I had also indicated, my lord, if your lordship sees the order dated 24/7/2021, what is now sought to be stayed, my lord, is already a part of that, which has not been stayed by this honorable court.
Please, my lord, we've moved applications for stay of Annexure C and Annexure D to the writ petition, my lord, and also for the payment of any amounts that are due to the workers who will be retiring. The applications may have to be considered, my lord. The senior counsel wishes to argue them.
My lord, I will file objections. My lord, matter can be heard and disposed of on merits itself. My lord. On 10 days, if your lordship grants me, my lord, I will file the objections.
All right. At the request of learned counsel for the respondents, release this matter on 14th of March 2020.
Instead of 14th, may I request for 15th, my lord?
15th of March 2022, before which statement of objections shall be filed at the hands of the respondents.
Obliged.
The copy is served on the learned counsel for petitioner in advance.
Very good. Obliged.
Grateful, my lord.
28, I appear for the respondents. Selection to the post of assistant engineer. Question is not whether, but the draft can be operated for the purpose of selection. Once the selection process is already begun, respondent issued notification for Annexure G, page 45. For 2018, I request not Page 48, the post of assistant engineer is notified and qualifications are described. Lord, this matter may I submit, my lord, 28. What has happened here, my lord? The third respondent was selected, and thereafter, my lord, the third respondent is not reported. Though letters were sent to him, my lord, 2 letters have been sent. Now, my lord, according to the law, my lord, we'll have to send him one more letter. And my lord, if he doesn't, all possibilities are there, my lord, because he is already working in the central government. My lord, therefore, my lord, it may be adjourned to 2 weeks, my lord. If he does not report, my lord, the petitioner will be definitely accommodated there.
Learned counsel, Shri B.L. Sanjeev, appearing for the first respondent board, submits that although appointment order has been given to the second respondent, the second respondent has not responded and he has not joined for duties till now. So, therefore, the learned counsel submits that if the matter is taken up after 2 weeks, submission will be made as to whether the second respondent has joined the duty or any other order would be passed by the respondent board, cancelling the appointment of the second respondent. So, next para. Consequently, release this matter on 21st of March 2022.
Selection itself is stayed by us.
Has been stayed, huh?
Yes. The order sheet dated 21/9/2021. The detailed order is passed. And so forth. Once the game has begun, you cannot change the rules of the game. 21/9/2021.
ಫೈನಲ್ ಸೆಲೆಕ್ಟ್ ಲಿಸ್ಟ್ ಅನ್ನ ಸ್ಟೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ವಲ್ಲ.
Stay. I have also made an application for vacating the stay, my lord. But in the meantime, my lord, now that he is the only respondent, if he does not report, my lord, all possibilities not reporting. So then the petitioner will be accommodated. Once for all, the matter would be disposed of.
It's all right. No, it's all right. ಅಲ್ಲಿ ಇನ್ನೊಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಮಾಡ್ಬಿಟ್ಟು when counsel for the petitioner draws the attention of this court to the interim order dated 21/9/2021, whereby the final select list of assistant engineers (bracket civil) which has been impugned in this writ petition has been stayed. Full stop. Next, nevertheless, list this matter. Has been stayed insofar as the second respondent is concerned. Matter had come up the other day. ಯಾರು ಜೈಕರ್ ಶೆಟ್ಟಿ ಅವರಿದ್ರಾ ಈ ಸರಿ ಈ ಸೈಡ್? ಹೇಳಿದ್ದಾರೆ. ಪಾಸ್ ಓವರ್. Matters called out. There is no representation for the petitioner. Clear counsel for respondent number 3 submits that he has not received a copy of IA number 2 of 2022. Full stop. Clear counsel for the petitioner is directed to serve a copy of the IA on the learned counsel for the respondent. Full stop. Yes. List this matter after 2 weeks. What is this? Respondent number 3 not made party in this writ petition. R3 not made party in this writ petition. R3 ಎಲ್ಲಿ?
Yes, register number 8 that is concerned. That was the office objection was raised. Similar objection when we approach the Honorable Court. Such objection was raised. Similar matters are pending. But as soon as BBMP employees are concerned, the concerned authority to pass the order of enforcement is the commissioner himself, not the state government. Here, the order of enforcement, which is at section C page 40. Relevant portion is at page 45. The order of enforcement passed by the state government. The not for the stay of subsequent proceedings. two interviews have been passed. One in the classification of service, another classification of GMK. The officers that the office will be
DM?
GMK on another. Both occasions. Officer not raise any objection with respect to that minor aspect. Now, I rectify no issue with that. Or I start to stay of subsequent proceedings, subsequent inquiry. Also start for resolution of motion. If I may, both occasions do not this one report has granted. The order of interest in Malad is at page 40.
Yeah, no, all the officers in the BBMP are found to be involved in this kind of activities. Everyone, almost all of them are under a cloud. And on technical grounds, you are getting the benefit for them. Huh? Even in today's newspaper, as we have seen, so much of irregularities.
Some delay in issuing the notice at 320. Only because there is a delay. They say it is derivation of duty. Yes,
No, it's not only about 321.
There are cases where there have been illegalities committed by the authorities that respective facts. What has happened? The result of this on the report also not produced the judgment of this on the report.
No, that is why I said on technicalities, you may succeed. That is a different issue. But everyone, and we also know that in fact, this court can take judicial note of this fact. That it is not only the duty of these engineers to just sanction the plans. What has to be done after the sanctioning of the plan? When they dig the ground for foundation, whether it is according to the plan sanction, whether they are putting up the construction as per the plan, ಅದನ್ನ ಯಾರು ಏನು ನೋಡೋದೇ ಬೇಡವಾ? ಅದೆಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿ ಆಯಾ ಟೈಮ್ಗೆ ಅವ್ರು ಮಾಡ್ಕೊಂಡು ಹೋದ್ರೆ where the question of illegal constructions? So therefore, it is not just taking action under section 321. Office objection regarding respond number 3 is overruled. Learned AGA is directed to take notice for respond number 1. Learned counsel. ಬೇರೆ ಯಾರಿದ್ದಾರೆ BBMP-ಗೆ? BS Gautam is directed to take notice for respond number 2.
Please, my lord, please.
Then counsel Shri Venkatesh Arbatti is directed to take notice for respond number 3. Next para. Then counsel for the petitioner submits that under similar circumstances in WP number 3709 of 2022 and WP number 2780 of 2022, this code while taking note of the decision of the Honorable Division Bench in the case of BC Sandeep versus State and others, in writ appeal number 634 of 2021. ಇನ್ನೊಂದ್ರೆ ನಾವು ಯಾವ್ದು ಮಾಡಿದೀವಮ್ಮ ಈಗ ಈ BC ಸಂದೀಪ್ ಅಂತ ಹಾಕಿದ್ರೆ ಬಂದ್ಬಿಡುತ್ತೆ. So similar order. Yes.
Madam, sorry, my lord, please pay CL number 30, my lord, some internet problem, my lord.
I think you have given the same benefit for the purpose of considering your case for promotion. ಅದೇ ಇದೆ ಅದರಲ್ಲಿ ಇದೆ same orders.
Lord, I'm sorry, Lord, serial number 30, Lord, some internet problem, Lord, serial number 30. Lord, just missed. But I have filed IAPR amendment, Lord, in this matter.
ಅದು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಂತ ಅವ್ರು ಕಾಪಿ ಕೊಡಿ ಮೊದಲು.
No, you have sent it, Lord. You have sent it, Lord. We have sent it online. You have sent it, Lord. To mail you have mailed.
ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರು. I have directed you to survey copy and I have given a date also.
Monday, Lord, sorry, Lord, Monday.
Monday date ಕೊಟ್ಟಿದ್ದಾರೆ.
He is being harassed by.
In fact, ಅವ್ರಿಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಂತೆ.
ಹೌದು, Monday.
ಅವ್ರಿಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಂತೆ. So I have given some date. It will come up.
Monday, Lord, Monday, Lord.
Yes.
Disposal, number 32, give Nagoshan.
In election. Huh? You know? Previous? Ada 10th. I list this matter on 10th of March. Yes. It is an election matter. Huh? ಏನ್ ಅಮೆಂಡ್ ಮಾಡಿದಿರಾ? ಎಲ್ಲಿ ಬಂದಿಲ್ಲ ನೀವು ಅಮೆಂಡೆಡ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲೂ ಆತರ ಏನ್ ಪ್ರೇಯರ್ ಏನಿಲ್ಲ. ಅಮೆಂಡ್ ಮಾಡಿಲ್ವಲ್ಲ. ಯು ನಾಟ್ ಇವನ್ ಅಮೆಂಡೆಡ್ ದಿ. And if that is permitted and there is a challenge raised to the provision of law, it has to place before the division bench. Section challenge ಮಾಡಿದಾರಂತೆ. So as per the new circular, it has, but ಇಲ್ಲ amendment ಬಂದಿಲ್ಲ. ತೋರಿಸಿ, ಅವರು ತೋರಿಸಿ. ಇಲ್ಲ, ಅಲ್ಲಿಲ್ಲ, it is not there. ಸರಿ ಆಯ್ತು, ಅಮೆಂಡ್ ಮಾಡಿದ್ದೀರಾ ನೀವು ಅದ್ರ ಪ್ರಕಾರ? ಇನ್ನೂ ಹಾಕಿಲ್ಲ. And you have not carried out the amendment also. You dispense with them. ಅದರಲ್ಲಿ ಅವಾಗಲೇ ಆರ್ಡರ್ ಮಾಡಬೇಕಾಗಿತ್ತು. If your prayer has been permitted to challenging the provision of law. ಬಹಳ ಹಿಂದೆ ಬಂತು, ಬಹಳ ಹಿಂದೆ ಬಂತು. 7/2021 ಹೇಳ್ತಾ ಇದೀರಿ. ಆಯ್ತು, ಬರ್ಕೊಳ್ಳೇನು. When a counsel for the petitioner submits that IN number 5 of 2018 was allowed by order dated 6/7/2021 permitting the petitioner to add a prayer, permitting the petitioner to amend the writ petition along with a prayer challenging the constitutional validity of section 31(3)(a) of the Karnataka Cooperative Societies Act. Stop. ಇದು amended petition ಇನ್ನು ಹಾಕಿಲ್ಲ. Stop. Although 2 weeks were granted to file amended writ petition, comma, the same has not been complied with. Full stop. Next para. Nevertheless, comma, in terms of the notification issued by this court, comma, since there is a challenge raised to a provision of law, comma, this matter has to be placed before the honorable division bench. Full stop. The office is directed to act accordingly. Yes. The petitioner is learned counsel for petitioner is permitted to file the amended writ petition within a period of 2 weeks, comma, along with a second set of the writ petition. Yes. A copy of the same shall be served on the learned counsel for the respondents, including the learned AGA. KLR. ಏನಪ್ಪ ಇವರು ಎಲ್ಲಿ ಹೊಸಮಠ ಅವರು? I'll release it from parted. Release from parted. ಇಲ್ಲ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ. ಅವಾಗ ಆ ಫ್ಲೋ ಅಲ್ಲೇ ಹೋಗ್ಬಿಟ್ಟಿದ್ರೆ ವಿ ಕುಡ್ ಹ್ಯಾವ್ ಫಿನಿಶ್ಡ್ ಇಟ್. ಅದೇ ಅದೇನೆ. I had asked the learned counsel to submit whether there was a creche provided, facility of creche available there.
Yes.
Huh?
Your lordship also has
Yes, come.
instructed us to produce the record.
ಏನ್ ಜಯಕರ್ ಶೆಟ್ಟಿ ಅವ್ರೆ? ಕ್ರೆಶ್ ಪ್ರೊವೈಡ್ ಮಾಡಿದಾರ ಇಲ್ವಾ? ನೋ ಫೆಸಿಲಿಟಿ ಆಫ್ ಕ್ರೆಶ್.
Meeting they have held. These employees are interested in the days of meeting. I have produced the next continuous. Last meeting. Very clear. It is not too many times. Really, semiconductor process is there. There are not toxic gas and chemicals using that. So when you see it, particularly the time, if still they are interested to get it done, they are ready. No matter what it is said. Opening it, attempt to do something. stated that creating. There are two teachers already operating, and we are also taking all assistance from them in other facilities. So if they want it, we can also provide that for present. And if they want it permanently in our premises, in spite of this health hazard, it will take some time because they have to construct a separate building after getting this action. Also mentioned, I just read.
Lordship, what is sufficient that ideally fresh which he has referred. It is 5 kilometers away from the premises.
Madam, they have written adjacent to this building.
Already checked with this line. The care facilities. I cannot be sure. I'm lactating mother. My child is only
adjacent to that. 5 kilometers becomes almost another side of animal.
Their document still says that there is no fresh facility.
Presently, it is not. I will just read why we are, because we have even parents meeting also we have made it very clear. If you are interested to go for it, we will consider. You are asking any transportation, you are ready.
I thought that's all right. Yes, that's about the crash facilities. Yes.
So where this child care leave is concerned.
Where is that? Maternity benefit act is in place.
Five suppose 5.
Now, first of all, you will have to point out to whom and all these provisions are applicable.
Yes, sir.
You please point out to that.
Your Lordship, I have two sufficiency.
You please point out from the provision of law.
Yes, Your Lordship.
It is applicable to whom?
I agree.
Please point out to that.
The CCS leave rules are applicable to central government employees, but it has been extended to public sector enterprises.
By whom?
Through an office memorandum. Your Lordship, I have submitted. I have submitted that documents for your Lordship. Office memorandum, Your Lordship. I memo dated 25 to 2022.
Page number?
Page number 2, document number 1. Clause B, Your Lordship.
Uniformity in facilities available to women employees.
CPSCs.
Like maternity leave and
In that, Your Lordship, 2 suppose B. Child care leave up to a maximum period of 2 years. That is 720 days. OM number 2008. Dated 11 September 2008 and 29 September 2008 of BOP.
At present, women employees of the central government have the following facilities.
Yes, sir. Your Lordship, we can see that office memorandum which I have submitted along with my petition, that is on page number 50.
No, you complete this reading.
Yes. Clause B, child care leave up to maximum.
Correct.
Then child adoption leave, Your Lordship.
Correct, madam. If you read point number 2, it says at present, women employees of the central government have the following facilities. Yes. Then.
The clause, point number 3, Your Lordship. Next page. Page number 3.
Yes.
The CPSCs formulate their own HR tools with the approval of their respective boards in consultation, if required, with the concerned ministries or departments. In the interest of ensuring the welfare of women employees, these HR rules must incorporate all statutory provisions
regarding other welfare measures, all the administrative ministries or departments are requested to advise the CPSCs under their administrative control to bring some uniformity in their rules in line with similar facilities available to women employees of the central government with approval of the respective boards. In any case, there should be no variation in such measures between different grades of employees in single CPSC.
So this is an advisory. This is an advisory. This is an advisory by the central government. There is no mandate.
Page number 76 and page number 86 also.
76 of the same.
This is an office memorandum. History of Personal Public Grievances and Department of Personal and Training. Security measures to contain the spread of novel coronavirus. Attendance of central government officials regarding the partial modification of this department's oil of even number dated the 3rd May 2021 on the above mentioned subject. It has been decided as under. Exact clause number 2, Your Lordship. Persons with disabilities and pregnant women employees may be exempted from undertaking office, but they shall continue to work from home.
Madam, these are two different things. Are you pressing on the implementations of the provisions of the Maternity Benefit Act, or are you asking for work at home facility in consequence of SOPs issued? What is it that you want?
My submission is in two parts, Your Lordship. One is I am eligible for child care leave.
You are not able to substantiate your contention, madam.
The next point is page number 86.
86.
Yes. My submissions are connected to the child care leave now. Center issues advisory to state governments duties to encourage work from home for nursing mothers. In the latest measure taken.
Again, this is an advisory.
Yes, Your Lordship. This is Corona, during Corona time. The government has.
So therefore, there are two different aspects.
Yes, Your Lordship. This is the first aspect of child
The first aspect is about the implementation of the provisions of this act.
Yes, Your Lordship.
That is your main contention. For that one, you will have to satisfy this court that this respondent corporation is also to follow the provisions of this act.
Yes, Your Lordship. Then Your Lordship may kindly read this Maternity Benefit Act in line with these advisories. Your Lordship, this is.
Those are all only advisories. Those are all only advisories. It is left to the public sector units to take a decision.
Your Lordship, that office memorandum was issued in 2014.
Yes.
Based in line with that office memorandum, there are case laws which I have submitted to Your Lordship. Their child care leave was granted. 2014, there is a clear direction from the government side to adopt child care leave also. Based on that, the court has passed order and has submitted those cases. If Your Lordship
That is you read out an order passed by the Central Administrative Tribunal. That is not binding on this court.
Your Lordship, during Corona time, there is no.
So you don't jump from this side to that side. The implementation of the SOPs is different. Are you now still contending on the implementation of this provision?
Yes, Your Lordship.
If that is so, then you will have to convince this court that this is applicable to the respondent corporation.
Yes, Your Lordship.
Yes. Otherwise, you give up that one and go to the other stand.
Yes, Your Lordship.
Yes.
May you read this press note, Your Lordship?
Which press note?
The page number 86, issued
Ah.
by this department. In a latest measure taken to protect the interests of workers, specifically nursing mothers at home, during the ongoing.
So this will be on COVID-19.
pandemic.
You are giving up on this one? You are giving up on this one?
Yes, Your Lordship. We will have to read together. Your Lordship. I try to work from home during Corona time. This particular press no speech.
Ah.
And at the same time, Maternity Benefit Act also provides these certain provisions to work from home. So these has to be read together. Government has issued an advisory to all the state government entities to encourage work from home for nursing mothers under the enabling provision for permitting work from home. For nursing mothers under the Section 5(5) of Maternity Benefit Act 2017. The Act provides that for the nature of work assigned to the women of such nature that she may work from home, the employer may allow her to do so after availing of the maternity benefit for such period and on such condition as the employer and the woman may mutually agree. Keeping in view the vulnerability of nursing mothers and their babies during the COVID pandemic and to save them from getting infected by the coronavirus, the Ministry of Labour and Employment has issued an advisory to all the state governments and UTs to encourage employers to allow to work from home to nursing mothers wherever the nature of work so permits. The state governments and UTs have been requested that steps may be taken to create awareness about Section 5(5) of the Act amongst the human workforce and the employers. The state governments and UTs have been further requested that advisories may be issued to the employers for allowing more and more nursing mothers to work from home. As per Section 5 of the Act, wherever nature of work so allows, it has been conveyed that employees may be advised to allow from work from home, wherever nature of work so allows, for no nursing mothers at least for a period of 1
Where
year.
does it talk about the public sector units? This is an advisory to the state governments and the union territories.
Union territories to encourage work from home.
Yes.
For nursing mothers.
Yes.
And to implement Section 5.
Correct.
Of the Maternity
Yes.
Benefit. When it comes to the submission from the respondent.
How old is the child now?
Child is 1 year 4 months.
You have had sufficient time.
Now I can, Your Lordship, join back to the organization. But during the peak time of Corona, even Your Lordship has also allowed us to work from home. We were also attending the proceedings online, Your Lordship. So consider that.
Madam, please understand that is possible if the nature of work is so. Some nature of work, if it is not possible, then where is the question of the employer allowing from work from home?
Your Lordship may continue. That is a research organization.
Yes. Research can be done in the laboratories, madam.
No, Your Lordship. That submission is my submission.
Anyway, I can't take your word for that one.
Your Lordship, I will submit that.
Yes.
Your Lordship may actually allow to submit.
Yes.
There is a team of 5 to 6 members in my particular team. So my work was connected to documentation, research, development, and connected in lithography. I had also got a chance to work from home. They had permitted me for some time. I have submitted my reports also. So that is why CITAR, the full form of CITAR is research organization.
Yes.
It is not a defense organization.
Yes, it's a research organization only, but research will take place where?
Yes. Your Lordship, research in the sense, 2 types of research definitely will apply here.
Madam, we can't take so much of liberties.
Your Lordship, my submission is Section 5(5) plus the case laws which I submitted before Your Lordship. As Your Lordship pointed out, Section 5(5) is discretionary in nature. I do agree, but that discretion has to be considered in a way. Your Lordship, that's a case law. When it comes to, I have already submitted Your Lordship. And we discuss Your Lordship when it comes to Indian Railway Catching and Booster Corporation.
Madam, we are not concerned with any specific case. When you are saying or when you are seeking implementation of the provisions of certain law, first thing you'll have to do is to show that these laws are applicable to them.
Maternity Benefit Act is applicable to.
That is all. First of all, you will have to convince this court about that one.
Your Lordship, Section 5(5) very clearly says.
5(5) is the implementation of provision, madam. The act applies to where? To whom? That is the question.
Your Lordship, the Act
Is it applicable to a private company?
Yes, Your Lordship. Even
Please point out then. Please point out then.
It is applicable.
If it is applicable even to a private company, then it is definitely applicable to them. Then you please point out then.
No employer shall, section 4.
Who is this no employer, madam? Who is an employer? See the definition of employer. 2D. Employer means
In relation to an establishment which is under the control of the government, a person or authority appointed by the government for the supervision and control of employees, or where no person or authority is so appointed the head of the department, in relation to an establishment under any local authority. The local authority, probably your worship, in Business Shops and Commercial Act is also applicable. The person appointed by such authority for the
in relation to an establishment which is under the control of the government.
Under any local authority, the person appointed by such authority for the supervision and control of employees, or where no person is so appointed, the chief executive officer of the local authority. And establishment means, your worship, next point, a factory, a mine, a plantation, an establishment where the persons are employed for the execution of equestrian, acrobatic, and other performances. A
Yes,
shop
sir.
or establishment. Shops and establishment.
As per the definition, employer means in relation to any establishment which is under the control of the government. Are you not under the control of the government? Irbodo. We can only go by the definition as provided under the Act.
They have submitted the HR policy, your worship, in page number 85.
HR policy is not
Your
there.
worship.
Even they not what is the election? It is 98 that DOPT has clarified. After the autonomous body name. That is also as CCL is. Just read.
Let us not go to all those things. The question is whether you fall under the definition of an employer as provided under the Act. So say, Adhyana consideration is there, please show that in any of the judgments of the Supreme Court, they have considered this aspect and they have said no central government. What is this? Autonomous bodies do not answer to the definition of employer. Please show. Ashte Mugito. Are you not funded by the government?
It is funded.
Then
they need not follow because it is not automatically applicable to them.
Yavadale, which decision?
Your worship, page number 85 of their statement. Maternity leave. Women executive employees are eligible for maternity leave in accordance with the provisions of the maternity benefit. The government has submitted from time to time. The themselves are mentioned. And there is no doubt that
maternity leave we have granted. So she is already explained that leave this one. Now she wants to go to CCA.
No, that is also that is also under this provision, under this statute, isn't it?
That is separate.
5.
Your worship was asking about the applicability of the maternity
Yes.
benefit. They themselves have mentioned that maternity benefit is
All right.
in addition to that,
This child care benefit, the child care benefit that you are asking for.
I'm asking for child care leave.
From where do you get that child care leave?
Your worship, that is based on the PSC's this particular office memorandum as extended. I am a even if I am an autonomous body according to them, I have submitted a document which says that I'm.
Madam, this child care leave is not a part of this Maternity Benefit Act.
Child care leave, 2 years of child care leave is not a part.
Is not a part of this one. Then from where do you get that?
Child care leave is based on this office memorandum.
Which office memorandum?
Page number 50. Page number 50. I should read it.
Hmm.
Grant of childcare leave.
Hmm.
The undersigned is directed to refer to para 1C of this department OM of even number dated 11 September 2008, according to which childcare leave can be granted to women employees having minor children below the age of 18 years for a maximum period of 2 years, that is 730 days during their entire service, for taking care of up to 2 children, whether for aiding or to look after any of their needs like examination, etc. The question as to whether childcare leave would be admissible for the third child below the age of 18 years and the procedure for grant of childcare leave have been under consideration in this department, and it has now been decided as follows. Childcare leave shall be admissible for 2 eldest surviving children only. The leave account for childcare leave shall be maintained in the pro forma accounts, and it shall be kept along with the service of the government servant concerned.
So there is no provision of law as such.
Provision is there in the CCS rules, but
In the
they are saying that CCS rules are not applicable to me. They have their own HR policy, but this HR policy is drafted based on 6-day commission. That is one argument I have. They have selected every provisions of the 6-day commission recommendation except that. This childcare leave is a confusion legislation. There are lots of case laws which states that even the Article 42 states maternity benefit has to be considered.
Therefore, they are saying whatever has been provided under the Maternity Benefit Act, we are giving. That is their contention.
If it is applicable to public sector enterprises, in page number 45, page number 39 says inaction leave. These organizations are coming under the control of the government.
Yes.
In that, Aeronautical Development Agency (ADA), Society for Integrated Circuit Technology Applied Research.
There is no difficulty. These are statutory corporations, companies, which are under the financial control of the central government. There is no difficulty about that. Yes.
So the applicability of this employment can be accepted here or extended here, or else you are one more point I can point out where the respondent has submitted. Page number 103, Your Worship. 16, point number 16. Leave rules and working hours to be as per DRDO norms and 5 days working in a week.
103.
103, which they have submitted. It's an office memorandum. They submit. Respondent has submitted.
102, Annexure R9.
Yes.
Minutes of 14th Stark employees meet.
2018. In that paragraph number 16. Leave rules and working hours to be as per DRDO norms. DRDO has childcare leave. And page number 104, para 26.
Leave rules as per DRDO can be proposed as and when the HR policy is being reviewed. 5 days working in a week can be proposed for approval of DOG.
This is 2018 minutes here. Even after 3 years, they haven't implemented that. In paragraph number 26, if a private government organization private or government organization, female employees are given additional benefits in the form of various policies like childcare leave, flexible timings, etc. Considering the fact that work from home may not be possible at few instances, parenting issues inherited due to lack of such policies should be taken seriously. Fresh daycare as per 2017 Act is other options. Maternity benefit Act 2000 applies only if the strength of women employees are 30 and above. This is absolutely wrong.
That's all right. They have admitted that it is applicable. Yes.
Creation of fresh and daycare is not advisable in the permissible sensitive and risk involved processes.
So there itself they have said why they have not established a creche is for this reason.
That is true, Your Lordship. What are the options available to a female mother, Your Lordship? Considering the Universal Declaration of Human Rights, considering the other benevolent legislations, beneficial legislation, which says that the motherhood has to be upheld or a sympathetic view has to
We can direct them to make provision to take care of the child. We will direct them. We will direct them. You go for work, you leave the child, they will take care of it.
This is a pandemic time.
Yes.
This century has seen this kind of situation we have never seen before. Considering that the government has issued office memorandum, considering that government has issued certain guidelines, all those guidelines we should also, Your Lordship, must consider. Because we haven't faced such a situation before. We don't have any majority benefit act or any other laws which is created only for pandemic time. Your Lordship, there are some case laws. If Your Lordship permits, I will read it some of the points.
Madam, to make that applicable to your case, you will have to first convince that that those decisions are passed in which type of cases. In which type of cases is it? Would it be applicable to the facts and circumstances of the present case? Please read. If you yes. If you are pointing out to any decision, you will have to first say it is decided under what circumstances in respect of what employees.
Yes, Your Lordship, that is what I have
Yes.
submitted. The
Yes.
first case law is related to IRCTC. They are saying that we are an
IRCTC, you are referring to railways.
Yes, Your Lordship.
Railways is a department of the central government.
No, Your Lordship. That is a public sector enterprises. We are, according to them, we are an autonomous body. So child care leave, if the Lordship goes in a very strict manner, then the child care leave is only applicable to central.
Madam, they have discussed all this. You have pointed out. You have pointed out to that discussion in that meeting. Yeah, they have discussed all those things. Not that they have not discussed any of these aspects. There itself, they have said, owing to the nature of the work done, it is not possible to provide for work from home. And why this creche is not provided for. Both those aspects have been covered here.
No, Your Lordship, I'm shifting section 5.5. Is where the nature of work assigned to a woman is of such nature that she may work from home, the employer may allow her to do so after vailing of the maternity benefit for such period. And all such
Which one?
as the employer and the woman may mutually agree. It is true that there are a lot of discretionary power is given.
In which one?
The discretionary power.
What did you read now?
Section 5.5.
Of this maternity benefit act.
Option can also be given. In case where the nature of work assigned to a woman is of such nature that she may work from home, the employer may allow her to do so.
That she may work from home. If it is of such a nature that she may work from home, that is answered in this paragraph number 26 that you read out just now. Madam, it all depends on the nature of work.
They haven't submitted any document which says that my nature of
You are reading the document saying that it is in your favor, but they have considered these aspects. They have said, be it private, government organization, female employees are given additional benefits in the form of various policies like childcare leave, flexible timings, etc. Considering the fact that work from home may not be possible at few instances, parenting issues inherited due to lack of such policies should be taken seriously. Creche, daycare, as per 2017 Act, is another option. Regarding that one also, they said creation of creche and daycare is not advisable within the premises due to sensitive and risk involved process, usage of chemicals and toxic gases. They have considered all this.
What is the option available to me? Being a mother of 1 year child, and my delivery was done during Corona time. I have 2 children.
Madam, you have been at home for 1 year, 4 months now.
I can rejoin, Your Lordship.
Please rejoin. We will direct them to make some arrangements for the child. You have stated.
Already a breach is there.
Your Lordship, regularize my absence, that is not my prayer. And
That you have taken the risk, madam. Why did you take that risk? You should have gone and joined, and you could have brought it to their notice that this is the problem, what to do.
My 3 months child, even adults are
No.
exposing to Corona.
No.
How can I leave a 3 months child?
The benefit given for a mother who was delivered, as per this act, you are entitled for all those benefits. There is no difficulty.
Section 5.5 is for the benefit of children. And this particular
Madam,
section
I am
is not-
talking about the leave facility provided as per this act. All that leave has been given to you.
Yes, Your Lordship.
Then?
No, Your Lordship, that is during lockdown time.
It is not because of lockdown, madam.
During lockdown, we were
Lockdown is a different thing.
Your Lordship, section 5.5, Your Lordship. Work from home option is given.
Wo-
Even during Corona time.
Here
it is
they have
not
considered
available.
that one. They have said it's not possible here.
Even if it is not available during Corona time, this provision itself is meaningless. My child is only three months old. Can I apply?
Please
for-
understand, during lockdown, not only you, even the other employees, including male employees, were given this option. We do not know how far the work could be done from home,
Your
but
Lordship,
no other option.
Your Lordship.
It all depends on the nature of work, madam. You don't compare this work with the work that you are doing in the laboratory.
Even private employees.
Here it is possible to make some arrangements, and we are doing it, going out with this one.
At present, there are no options. When I took this option of working from home, this fresh facility was not there. That they themselves are agreed.
Now they are on record in their statement of objections, saying that they will take care of the child. You please go. Paragraph number.
That's memo. Just now. Because someone has reached it.
Yes.
Third paragraph. The start is located adjacent to and limited. We are awaiting lot of facilities of IT limited, such as waters, hospital, ambulance, etc. for our employees. IT limited is also having its facility, which employees, including the petitioner, are interested. Start will ensure that admission of employee children there. If no employees still persist for creation of facilities inside the staff, even with the unsafe conditions explained above, we have to obtain necessary financial sanction from competent authority. It takes around 1 year. So for the present moment, we can extend that also. Also, employees.
Yes. But
They haven't submitted any documents before your lordship to prove that my presence is appeared in the laboratory.
You have made meeting.
You have mentioned it, they have mentioned in their written statement, that is true.
madam, you are working as what? Then this is not a administrative work that you are doing, isn't it? there are other, probably there are other employees who are doing administrative work, unlike you. If such a contention would have come from their side, probably this court could have considered. You are an engineer. You are an engineer working in this organization, and you know what are your duties.
Your Lordship, I am an engineer, and at the same time, I am a mother of 1 year old, where my child was born during Corona peak time.
Yes,
That
madam.
also has to be
From 1 year, 4 months, you are there at home.
Your Lordship, considering that there are government has also issued notification
Yes.
saying that work from home should be allowed.
Yes.
It's a government
Work.
organization or an extended arm of government.
Argument was funded by state government.
This is in respect of Valmi, Water and Land Management Institute. It's a society registered under the Society Registration Act.
Here also the Maharashtra government comes. Still, Supreme Court said no, to them to adopt or not.
Nowhere in their document they have mentioned as an autonomous body. They have mentioned as a government of India company.
Madam, at any rate, it cannot be government of India itself. It is a government company. It is a government company. But can it be equated to a central government?
That is why I am pointing out the PS, the public sector.
Correct, madam. All these public sector units that you are talking of, though they are fully controlled by the central government, they will not become central government themselves. Please understand.
Mentioned parity between employees of NWSDA and autonomous body under aegis and control of the Ministry of Water Resources, central government employees, and principle of parity inapplicable to employees of.
Where are you reading?
That is in page 27.
At
note B. Here the question was parity they have asked for bigger attention.
What is this NWDA? National Water Development Agency.
Autonomous body under aegis and the control of Ministry of Water Resources, central government and central government employees, and parity, principle of parity inapplicable to employees.
Sir, there are direct decisions in respect of these public sector units only.
Yes.
Why don't you get that one? She is talking about public sector units, and I am sure there are any number of decisions in respect of public sector units only. They will not become central government.
But I have submitted a document which says that public, based on the memorandum, child care leave can be granted for public sector enterprises. Your Lordship, may kindly see page number 98 of the document which they have submitted. Page number 98, Your Lordship.
Madam, they have specifically considered the question of child care leave in the document that you pointed out.
I'm giving the child care leave, Your Lordship.
Ah.
And at least I'm asking Your Lordship the benefit of the Maternity Benefit Act, which says that work from home is also permissible. Now, if
Madam, it is very clear there also. There also, it all depends on the nature of work. It is not a blanket. It is not a blanket provision. Please read that provision once again. Please read that provision once again. It says depending on the nature of work.
My submission is that the nature of assigned to me is research.
No,
because
no,
I'm
no.
working in a research organization.
Research can be done only in laboratories as we understand.
Your Lordship,
We
that-
can't take your word for it, saying that I can do my research even at my house.
That is what I'm
No,
saying.
no.
I have submitted those case laws which says that
Yes.
when it comes to a female employee, when it comes to a motherhood, the employer has to consider it in a sympathetic way. I have submitted the case laws. Before moving to that, Your Lordship,
Yes.
page number 98, Your Lordship.
Madam, you have been at house for more than 1 year, 4 months now.
I can rejoin, Your Lordship.
Please rejoin.
I'll rejoin.
Yes.
They have taken certain disciplinary actions against me.
Huh?
They have taken certain disciplinary action.
What is
against
that?
me. My salary is given from June onwards.
From
I'm
June.
ready to join. That's not fun.
Regularization. You ask for regularization. You are not applied for. Because she is not in the regular. She has not voted for it. Since 24/5.
Anyway, we will grant you liberty. We will grant you liberty to make a representation to reconsider their decision regarding the non-payment of salary for that period. And if they don't consider it in your favor, then you are free to question it in accordance with that. We will grant you that liberty.
So far as public sector, ask her. Okay, 58, 59, last 59, last 9, para 9. We have heard 11% of the party and find that are not sustainable. First, we have and the benefit of state elections commissions for government servant. Departmental, it is not even the hand of the responsibility. She is a government servant, and rightly so, as she is an employee in an autonomous body, municipal corporation statute. Departmental candidates is in the respect of the candidates who are working in the concerned department, education. The circular of the government of India, dated 29 and 73 has made it clear that benefit of wage reduction is only meant for civil employees of the central government and not to the employees of the autonomous body and public sector undertaking. What is opposition? Therefore, the respondent is an employee of an autonomous body, the corporation.
Is Your Lordship, I do agree that I am from an autonomous body. Your Lordship, kindly see page number 98, which they have submitted. In that, there is a question whether given employees of public sector undertakings or bodies, etc., are entitled to CCA, child care. Orders issued by DOPT are not automatically applicable to the employees of central public sector undertakings or autonomous bodies, banks, etc. It is for the PSU's autonomous body to decide the applicability of the rules or instructions issued for the central government employees to their employees in consultation with their administrative ministry. They can adopt this.
Correct, they can.
That's what they have mentioned. But they have taken a decision that we are not adopting child care. But whatever benefits available to this attractive system, all those things they have adopted, except child care. That is what I'm insisting on one point. This is a selective discrimination. One point may read from the case law, Your Lordship, which I have submitted in page number 90. We are required to make labor laws in conformity with the recommendations made by the International Labour Organization, read with Article 42 of the Constitution of India. According to the Article 42 of the Constitution of India, the state is required to make provision for securing just and human conditions of work and for maternity relief. The objective of ILO to conduct the survey was to promote motherhood and child care as well as promote gender equality. Every female employee and male employee, whether appointed on regular basis, contractual basis, ad hoc, tenure or temporary basis, have a fundamental right to reasonable duration of maternity leave as well as paternity leave, child care leave, and adoption leave to promote motherhood and child care under Article 21 of the Constitution of read with Article 42 of the Constitution of India. The state government is also directed to grant child care leave. In this case, the court has granted. The state government also to implement child care leave of 730 days. All the female employees, whether appointed on regular basis, contractual basis, and go for tender or temporary basis, having minor children, with a rider that the child should not be more than 18 years of age or older. One more thing here. We must remark that CCS are special types of leaves which are prescribed for the benefit of the child. They serve a larger societal goal and public interest in furthering every individual's right to a wholesome family life, securing the interest and health of infants, all of which are answered by Article 21 of the Constitution of India. Public employees should not ordinarily be denying CCL to a mother unless it is for compelling and overriding public interest considerations. It would not have been in a case where the child was suffering the discretion for granting CCL to be exercised liberally by the employees, keeping its objectives and underlying purposes in mind. There are many case laws that have already submitted.
Madam, please understand that even a woman working in a private company,
yes,
she would also want to have all these benefits.
Even an employee
Isn't it?
working in a private organization, even if it is a one employee, maternity benefit act is
Correct.
available to them.
Isn't it?
Your Lordship, now even all the MNCs are permitted employees to work from home during Corona time, thanks to the health of their employees. Who should I approach for a one-day child?
Please, no. Please don't jump to the question of work from home because of the Corona situation. We are not, that's a different aspect. If you want the implementation of all these provisions, where so much of benefit is given to a woman for the sake of maternity, my question to you is not a woman who is working in a private sector, a private company, not entitled for these benefits? Is she entitled or not? Is she not equated to any other woman working in under the central government or the state government? Why this provision is not made applicable to a woman working in a private company?
Private company, there are maternity benefit, work from home option they are giving.
They have their own policies.
They have their own policy.
They have to have their policy. They will have their policy. But you can't insist. You can't insist in respect of a private company employee to have the same benefit as is given to a person working under the central government or the state government. Isn't it?
I understood your logic.
Therefore,
Most of the companies are
please understand, that is why the central government, even in all their circulars, have not mandated that it has to be adopted by this public sector units. They are aware to the extent to which they can direct. That is why it is not a direction, it is only an advisory.
Maternity benefit, it is not for the mother. According to me, it is for the child.
Correct, madam. Both.
It is taking care of the child.
Definitely.
I am not asking the benefit to me.
So therefore, no, that is why I asked you. That is why I asked you.
I'm an acting mother. Situation is Corona. I can't. Even schools are not open. Last week they have opened. Where should I put my child? Now females are even in military. So all these things.
Now they have made provision. You please go. You make use of that facility. If you have any further difficulty, you please put it to them in respect of your other benefits that they have taken away. We will permit you to make a representation. Let them consider it sympathetically. We will do that. Yes, please do that.
Whatever leave I have taken, we are also
we will permit you to make a representation, and we will also direct them to consider it sympathetically. Yes.
One more point because my mother.
We are not paying salary. Just the
Adiyana irli. She will. Please understand. Not necessary, sir. We will give her the liberty to make a representation. You please consider it in accordance with law. Yes. The petitioner, who is working as a senior executive engineer, at the third respondent, Semiconductor Technology and Applied Research Center, bracketally for short, STARC, stock, is before this court. Where is this annexure CC page number? Annexure C only, no?
No, Your Worship. Annexure CC. Page number 101. Towards the end, they have mentioned that if you're not regularizing the absence of fee without pay immediately, the period will be declared as unauthorized in personal reports and FIA department. My salary from June itself is different here.
Yes.
The petitioner is working as a senior executive engineer is before this court.
Agreed of. The communication dated 7/8/2021 at annexure CC. Communication dated 27/11/2021 at annexure GG. And is seeking directions to the third respondent to consider her representations dated 6/7/2021 and 12/7/2021 for sanction of child care leave with retrospective effect. And to regularize the petitioner's salary and to release the salary withheld from 24th of May 2021. Stop. A prayer is also made seeking directions to the third respondent to reimburse the medical bills furnished by the petitioner.
Next Monday.
Stop. Next para. The petitioner delivered a baby girl on 19/8/2020. Stop. She has been on leave from
19/8/2020. Maternity leave is from 19/8/2020 to 15/3/2020.
She was on maternity leave from
19/8/2020 to 15/3/2020.
19/8/2020 to 15/3/2021. Para 3013. The petitioner thereafter availed personal leave from 15/2/2021 to 26/4/2021. However, it is the contention of the petitioner that during the second wave of COVID-19 and the lockdown announced by the government of Karnataka, the petitioner was permitted the benefit given to the other employees during the lockdown period. So, the third respondent also does not deny the fact that the petitioner's attendance was regularized up to 23/5/2021. Stop. However, when the petitioner did not join duty after the sanctioned leave was exhausted, the impugned communication dated 7/8/2021 was issued to the petitioner, stating that she was staying away from duty without sanction of leave. And the overstay without sanction of leave would be treated as unauthorized absence. Full stop. The petitioner was informed that she would not be entitled for leave salary for the unauthorized period of absence. Stop. The petitioner was also informed that disciplinary action would be initiated against her willful absence from duty after the expiry of leave period sanctioned by the management. Full stop. The petitioner responded to the said communication while pointing out to the benefits that were required to be provided to a woman under maternity, in terms of the Maternity Benefit Act, 1961, and the notification issued by the central government. Where is that?
Office memo, page number 50. Make sure
And the notification issued by the
and the official memorandum dated 29th of September 2008, which provides for grant of child care leave to women employees. Yes, Yenga's sentence, how was it started?
The petitioner responded to the said communication while pointing out to the benefits that were required to be provided to women under maternity in terms of the Maternity Benefits Act 1961 and the official memorandum dated 29/9/2008, which provides for grant of child care leave to women employees.
One more office memorandum, sorry, page number 76 also.
Having minor children below the age of 18 years. Full stop. Huh?
One more office memorandum in page number 76 also. It is 6 May 2020.
Official memoranda, 2 official memoranda dated so and so, and 6th of May 2021. Issued by the Ministry of Personnel, Public Grievances and Pensions, Department of Personnel and Training, Government of India. So,
Press note in page number 86 also.
you had filed an application before the CAT, is that?
Yes, sir.
For what?
Application before the
Central
CAT
Administrative
is
Tribunal.
yours.
Huh?
It was not at,
it was not.
We are not listed. Establishment matter section 14.
Petitioner had also approached the Central Administrative Tribunal at Bengaluru, seeking similar relief. Full stop. The third respondent thereafter sent one more communication dated 27/11/2021, noticing the fact that the application filed by the petitioner was dismissed as withdrawn, by order dated 16/11/2021. Full stop. The petitioner was once again called upon to join duties immediately and regularize the absence from 24/5/2021. Full stop. Nevertheless, the petitioner has filed the instant writ petition with the prayers as noticed herein above. Full stop. Next para. Learned counsel for the petitioner submits that the provisions of the Maternity Benefit Act 1961 is applicable to the petitioner who is an employee of the third respondent organization, which is a fully funded organization controlled by the Government of India. Stop. It is also contended that the third respondent does not dispute the fact that the leave benefits which are available to the employees of the Defense Research Development Organization, bracketed DRDO, close, is also made applicable to the employees of the third respondent organization. Stop. The learned counsel would draw the attention of this court to section 5, bracket 5 of the Act 1961 to contend that the petitioner should be allowed to carry on her work from home after availing the maternity benefit for the period as provided under the Act. So, the learned counsel would further contend that notifications have been issued by the central government, directing all the public sector units, which includes the third respondent organization, to ensure that as far as possible, provision should be made to lactating mothers to work from home, in view of the COVID-19 pandemic, in view of the prevalence of the COVID-19 pandemic. Stop. It is submitted that in terms of the directions issued by the Government of India, it is the duty of the third respondent organization to provide for child care leave and to permit the petitioner to work from home until it is declared by the central government or state government that there is no need for its employees to work from home. Stop. The learned counsel has sought to place reliance on a decision of the Central Administrative Tribunal. What is that? It's there in your memo of citation, isn't it? Memo of citation. Principal bench at New Delhi. In the case of Sapla SAPHLA Rani versus Chairman Managing Director, RITES Limited. Stop. For contra, learned counsel for the respondents. Would submit. That the benefit of the Maternity Benefit Act, 1961, as applicable to the third respondent organization has been granted to the petitioner. Stop. However, it is submitted that the third respondent is a society registered under the Societies Registration Act, and it is an autonomous body. Stop. The third respondent has its own rules and regulations and policy, HR policy, in the matter of grant of maternity leave and other service benefits. Stop. It is also admitted by the respondents in the statement of objections that in the matter of leave and leave concessions, it has adopted the policy of the DRDO, and it is made applicable to its employees. However, in respect of child care leave, in a meeting, in a meeting of the 14th STARC employees meet held on 31st of March 2018, the third respondent has considered the request made by its employees, especially in respect of female employees who sought additional benefits in the form of various policies like child care leave, flexible timings, etc. Semicolon. Considering the fact that work from home may not be possible at few instances, parenting issues inherited due to lack of such policies should be taken seriously. Full stop. It was decided that creche and daycare facilities, as per what is this, a 2017 Act? Maternity Benefit Act, 2017 was an option. Full stop. However, it was specifically decided that creation of creche and daycare facility was not advisable within the premises due to sensitive and risk involved processes, usage of chemicals and toxic gases. Full stop. Nevertheless, it was also decided that if some of the employees are interested, then the matter can be taken up with the CAIR. What is that? Center for Artificial Intelligence Research. Robotics. Close. For availing creche facilities. Full stop. During the course of the argument, when this court probed the third respondent as to whether creche facilities were made available, information is given by the deputy manager -P&A on behalf of the third respondent organization that consequent to the decision taken, consequent to the resolution passed on 31st of March 2018, no requests were made by the employees seeking establishment of creche facility within the premises. So, nevertheless, it is stated that arrangement is made at the adjacent. Arrangement can be made at the adjacent ITI Limited complex, which already has facilities such as quarters, hospital, ambulance, etc.
We are availing that facility already. This is also you can avail.
ಹಂಗಾದ್ರೆ ಫಸ್ಟ್ ಒನ್ ಅದೇ ಹಾಕೊಳ್ಳಿ, ಕ್ರೆಶ್ ಫೆಸಿಲಿಟಿ ಅಂತ ಹಾಕೊಳ್ಳಿ. ಕ್ರೆಶ್ ಫೆಸಿಲಿಟಿ, ಕ್ವಾರ್ಟರ್ಸ್, ಹಾಸ್ಪಿಟಲ್, ಆಂಬುಲೆನ್ಸ್ ಎಕ್ಸೆಟ್ರಾ. So the third respondent is already availing the other facilities such as quarters, hospital, ambulance, etc. from the ITI. Stop. Therefore, it is stated in the said communication that facility would be made for the petitioner, for the petitioner's child to make use of the creche facility, which is available in the ITI premises. Stop. It's further stated that if the women employee of the third respondent organization are still seeking the establishment of a creche in its premises, then appropriate financial sanction will have to be obtained from the competent authority for construction of the facility, and as and when the finances are provided for, the facility will be provided. Stop. Next paragraph. Learned counsel for the respondent, has submitted that at any rate, the third respondent organization cannot be equated to the government of India and the facilities available to the central government employees, be it in the nature of providing maternity leave, child care leave, and other facilities, cannot be automatically adopted to the third respondent organization. Full stop. The learned counsel would submit that material has been placed along with the statement of objection to support the contention of the learned counsel that ಏನಂತ ಹೇಳಿದ್ರೆ
Counsel would submit that material has been placed along with the statement of objections to support the content.
Along with the statement of objection at annexure R7 issued by the DOPT, Government of India, answering the query as to whether women employees of public sector undertakings or bodies, etc., are entitled to child care leave, that the orders issued by the DOPT are not automatically applicable to the employees of central public sector undertakings or autonomous bodies, banks, etc. Full stop. It has been made clear by the DOPT that it is for the PSUs or autonomous bodies to decide the applicability of the rules or instructions issued for the central government employees to their employees in consultation with their administrative ministries. Full stop. Consequent to the instructions and communications made by the DOPT, a resolution has been passed by the Board of Governors of the third respondent organization on 22/9/2021 regarding implementation of child care leave in the units of the third respondent organization. Stop. It was decided, it was resolved that the organization will not implement child care leave for its employees at its units and foundries which are involved in production and implementation of since such facilities would affect the production schedules and delivery timelines. Stop. Third, the learned counsel for the petitioner, learned counsel for the respondents, and peruse the petition papers. Full stop. Next para. The contentions of the petitioner in respect of grant of child care leave, comma, proceeds on the footing that all the employees of the Government of India are eligible for the said facility. Full stop. Though reference is made to section 5(5) of the Maternity Benefit Act, 1961, it is evident said provision that maternity benefits such as work from home after availing the maternity benefit to be given only in case where the nature of work assigned to the woman is such that it is possible for her to work from home. So, in this regard, a specific decision is taken by the third respondent organization in its meeting held along with his employees on 31/3/2018, at annexure R9, paragraph number 26, that the premises of the third respondent organization is sensitive and involved with risk, due to usage of chemicals and toxic gases. Full stop. The employees working with the third respondent organization are involved in research work, which is both sensitive as well as complicated. Stop. Sensitive, in the nature of the work done in the sense that the research is for the benefit of the Government of India which uses the facility in sensitive fields and the research work will not be divulged to the public. So, this itself would prove that the nature of work assigned to the petitioner cannot be carried on from home. Stop. The respondents are also on record, in their statement of objections that even during the period of lockdown, the top officials from the cadre of deputy managers have been functioning from the premises itself. Stop. Next para. Insofar as the child care leave, as rightly pointed out by the learned counsel for the respondent, consequent to point out this resolution at an R13 was taken consequent to $112. That was consequent to what? Munche point out madidri ನೀವು. ಇದು question frequent FAQs. Where is that? 98.
Slightly pointed out by the learned counsel for the respondent, consequent to the
advisory given by the DOPT regarding applicability of the child care leave facility available to the employees of the central government, central government employees to the employees of the central public sectors, central public sector undertakings or autonomous bodies that decisions may be taken by the PSUs or autonomous bodies in consultation with their administrative ministries, the board of governors of the third respondent organization have specifically resolved on 22/9/2021 that they would not implement the child care leave facility in the organization, as it would affect the production schedules and delivery timelines. Stop. Next para. It is therefore clear that the petitioner has not been able to point out any specific provision of law or rules that would mandate the third respondent organization to grant child care leave facility as is available to the central government employees, to the petitioner or any other employee of the third respondent organization. Stop. Next para. Nevertheless, comma, during the course of the argument, comma, this court has noticed that by the impugned communications issued by the third respondent organization to the petitioner, comma, it has warned the petitioner about unauthorized absence and decision to hold and the consequence to hold that the absence, the willful absence will be treated as leave without pay. Full stop. The petitioner has also been informed that she will be liable for recovery and remittance comma in accordance with law. Full stop. However, comma, having regard to the peculiar facts and circumstances of this case, where the petitioner has been on leave commencing from 19/8/2020, comma, having exhausted the leave sanctioned in her account. Stop. This court cannot lose sight of the fact that during the period of delivery and post delivery, comma, there were two serious waves of COVID-19 pandemic. Comma, firstly, which commenced during the month of March 2020 and for a prolonged period, lockdown was announced by the state government. Stop. The second wave of COVID-19 pandemic again commenced from is it November or December? Note on April 2021. Stop. This court would also take judicial notice of the fact that there was a third wave in the month of commencing from the month of November, December 2021. Stop. Therefore, if the petitioner was unable to join duties, comma, the third respondent organization is required to have a sympathetic view towards the petitioner. Stop. During the course of the argument, the learned counsel for the petitioner has pleaded that the petitioner is ready and willing to join the services, join duty, comma, provided child care facility is provided to the newborn. Full stop. The learned counsel for the third respondent has made a statement along with a communication issued by the deputy manager on behalf of the third respondent that creche facility will be made available for the petitioner's child in the adjacent ITI premises. Full stop. Next para.
Same period also she had to join me after maternity leave. She has no working there. Before 2021.
7-4.
7/4/21 onwards she is
My child has weaning issue, you know. That person has to take a step.
Adikene, see, each facts and circumstances are different. We can't equate one case to another, especially in these kind of cases. They may have several complications. So we can't. Although it was pointed out by the learned counsel for the third respondent that another woman employee of the organization who also took the benefit of maternity leave, almost similar to the petitioner, however, has joined duty from 7/4/2021. Full stop.
from 2/4/2021.
2/4/2021. Full stop. But this court is the considered opinion that in such cases, parity cannot be drawn. Full stop. The difficulties of the mother may be different in each case, and therefore everything would depend on the facts and circumstances of each case. Stop. Next para. For the reasons foregoing, this court is of the considered opinion that although the prayer made by the petitioner regarding grant of child care leave cannot be granted, however, the third respondent, however, liberty is reserved to the petitioner to make fresh representations regarding the unauthorized absence and seek regularization of the same. Full stop. As and when such representation is given by the petitioner, after she joins duty, the third respondent shall consider such representation sympathetically and pass orders in the light of the observations made herein above. Full stop. Aditya.
To release the salary.
Madam, you have to first give a representation. Let them consider and pass orders. You will see. Next para. This writ petition is accordingly disposed of. Full stop. No orders has to pass. Huh? I've held in your favor. Alva. Yes. E group matters angala urgent helake agala. Let us see.
That's final hearing matter. Not to kindly fix a date because the petition.
All matters which have not reached today will come up next week. Yes.
Very well.
What observe? What observe?